Please be seated. Good morning. We will resume the bench trial in Adkins versus State of Idaho, case CV01-23-14744. We have at council table on the plaintiff's side, Ms. Dady, Mr. Herron, Ms. Pletcher for the state, Mr. Craig, Mr. Grigsby. Are we ready to resume with the presentation of the plaintiff's case in chief?
Yes, Your Honor.
All right. Go ahead, call your next witness.
Plaintiffs call Catherine Winstrom.
Good morning, Ms. Winstrom. Go ahead, Mr. Herron.
Please state your name for the record.
I'm Catherine Dell Winstrom.
Are you a physician?
Yes.
What is your specialty?
Obstetrics, maternal fetal medicine, and clinical genetics.
How many years have you been an OBGYN?
35.
Are you board certified?
Yes.
In what areas?
OBGYN, maternal fetal medicine, and clinical genetics.
Where did you go to medical school?
Case Western Reserve,
When did you graduate?
1983.
Did you complete a residency?
Yes.
In what?
OBGYN,
Where was that?
University of Illinois in Chicago.
And what did you do after completing your residency?
I did a maternal fetal medicine fellowship,
And what did you do after that?
a clinical genetics fellowship.
Where was your maternal fetal medicine fellowship?
I started it in Chicago at the University of Illinois, and I finished it at University of Iowa so that I could simultaneously do the genetics fellowship.
Why did you decide to pursue an MFM fellowship?
When I was a resident, I was struck by the fact that many women receive suboptimal care just because they were pregnant and because the practitioners that they saw when they were not pregnant really didn't know enough about pregnancy to give them good advice. They may not get x-rays that they received. They were told to discontinue medications, even though those medications were not dangerous and were required. And importantly, a lot of women I saw in the GYN clinic were told that because of whatever pre-existing medical condition they had, they should never get pregnant. And in reality, they could have gotten pregnant if they'd had support. So that's why I wanted to do maternal fetal medicine, to help those patients.
Why did you decide to pursue a fellowship in genetics?
Well, when I was a resident, OB ultrasound was now performed everywhere. The equipment was getting really good. Excuse me. And we were able to see structural abnormalities, but that wasn't enough to make a fetal diagnosis. So it wasn't enough, excuse me. Just identifying a structural defect isn't enough to make a diagnosis. If you see a cleft lip, it could just be an ordinary cleft lip, otherwise normal baby, or it could have one of a dozen terrible syndromes. And so it was hard to know what to do to give that child the best outcome. And I felt that doing a genetics fellowship would make me a much better fetal diagnostician and therefore be able to provide better care to those babies.
Throughout your career, in what states have you been licensed?
Illinois, Iowa, Alabama, Tennessee, Rhode Island, Connecticut, and Massachusetts.
You still have a clinical practice?
No, I'm retired from clinical practice.
Where do you currently work, though?
Well, I have an appointment at Brown University Medical School.
And what's your title?
Professor of Medical Science.
And what was your role immediately before your current role?
I was director of the Division of Maternal Fetal Medicine at Women and Infants Hospital in Providence.
What did your role there involve?
Well, it's a great situation. Rhode Island is so small that the majority of deliveries are done at that hospital, so there are 9,000 deliveries there. And my role was to lead the division that provided care to all the high-risk pregnancies. It's an academic training center, so we had trainees with us doing all our activities. But we generally covered our own maternal fetal medicine patients in clinics, so we saw our own patients from, I'm sorry. Okay. We had our own clinic for our own patients. We saw them from the beginning of pregnancy through postpartum. We also covered residence clinics. We did all the diagnostic ultrasounds, about 60 a day. And then we also covered labor and delivery in the antepartum service. So some MFMs confine their practice to clinical outpatient clinic activities, but we had someone in the hospital covering the hospital 24/7.
Okay. Where were you employed before Women and Infants?
Vanderbilt University.
Can you just briefly tell the court a little about your work at Vanderbilt?
Well, I was very fortunate to be able to work at their Fetal Diagnosis and Treatment Center. It's a unique center that cares for patients in the immediate geographic area and really across the country. And I was co-director along with a surgeon in pediatric genetics. And the goal was to have evaluate patients who'd been told there was something wrong with their fetus, but because they didn't know the exact diagnosis or what possible treatment options were, they were at a loss and were sent to our center. So we did ultrasound to get more detail about their anatomy. We did genetic testing if possible. We had a multidisciplinary group that included various pediatric specialists and also medical ethicists. We would get together and decide what the likely diagnosis was, try to figure out if there was any treatment that could improve fetal life or optimize delivery conditions that would give the baby a better start. And if possible, if there was something we could offer, then we would counsel the patient about all the options. She would meet privately with a medical ethicist, and if the patient wanted to go ahead with a treatment, we would provide the treatment.
We're handing you what's been marked as Plaintiffs Exhibit 16.
Thank you.
Do you recognize this document?
Yes,
What is it?
it's my CV.
Who prepared it?
I did.
Is it an accurate summary of your educational and professional history?
Yes.
Your Honor, plaintiffs offer Plaintiffs Exhibit 16.
Any objection?
It is hearsay, but I won't object if it's offered only to go to her qualifications and nothing else.
All right, that's agreed.
Agreed.
All right, Exhibit 16 is admitted.
Dr. Wenstrom, what does, in general, an MFM specialist do?
Well, we take care of patients who have pre-existing medical conditions before they get pregnant, to ensure that they get the best care possible, ideally starting with a preconception counseling appointment to discuss all the ways they could improve their outcome before they get pregnant, then managing them through their pregnancy and delivery. Then we also take care of patients who develop complications during the pregnancy that weren't anticipated. And we also support fetal issues the way I've discussed.
And why are MFMs important to care for those patients?
Because pregnancy really changes many things we know about physiology, and it's important to know how maternal physiology and the physiology of pregnancy is going to affect all these high-risk conditions and be able to offer advice that's unique and appropriate to the pregnancy condition.
Does an MFM provide care that's beyond the scope of OBGYN training and expertise?
Yes.
When you had a clinical practice, how many patients with high-risk pregnancies did you treat per year?
Our group had roughly 500 deliveries a year on our own, but we also accepted care of transfer patients coming into the hospital from other smaller hospitals, and either co-managed or accepted patients transferred from the private community.
Over the course of your career, how many patients with high-risk pregnancies would you estimate that you've delivered?
Before I got to Providence, I'd estimated that I'd done 9,000 deliveries.
Have you published any peer-reviewed articles?
Yes,
Approximately how many?
over 100.
Have you been in the leadership of Society for Maternal Fetal Medicine?
Yes.
What leadership position did you hold?
Well, I was on the board of directors for many years and eventually was elected president. So I served as president and then immediate past president.
And what did you do as president of SMFM?
The board of directors worked on issues relevant to MFM practice and problems related to our people that belong to our organization. My personal accomplishment was to start the SMFM publication project.
And the publications are those practice bulletins?
Yes, ACOG had always produced excellent practice bulletins, but we felt there was a need for practice bulletins designed for to treat more high-risk conditions, and therefore that's what we worked on.
You mentioned ACOG. Have you served on any ACOG committees?
Yes.
What committees?
I've been on the OB Practice Committee, the OB Practice Bulletin Committee, the Genetics Committee, and the CREOG Committee, which is the committee that designs the training in the residency training exam for residents.
Have you been on the board of directors?
Yes.
Have you been involved in the development of any ACOG practice bulletins?
Yes.
Do ACOG's practice bulletins ever differ based on which state or region the patient is located in?
No.
How do ACOG practice bulletins inform the standard of care for clinicians?
ACOG practice bulletins are based on the best evidence, the best scientific data analyzed to produce evidence-based recommendations for practice that basically form the scaffolding of essential practice goals. And then they're designed specifically so that they can be applied in any state with the recognition that local people will tweak small things to make those bulletins relevant to their community.
The tweaks, what are those tweaks based on?
Well, for example, if you're practicing obstetrics in a community where you don't have in-house anesthesia, then you're going to have to adjust. Well, actually, ACOG accounts for that. They don't require in-house anesthesia. But, we don't know what facilities will be available or what support staff will be available. And so those things have to be, decided locally.
Does the standard of care materially differ by location or region?
No.
To become a board-certified MFM, is there a test the candidate has to take?
There's a written test and an oral test.
And do those tests differ by state or region?
No.
You mentioned a few different categories of things that MFMs treat high-risk pregnancies. I wanted to talk briefly about the first category, which is pre-existing or underlying conditions. Do I have that right?
Yes.
How do patients with a pre-existing or underlying condition come to be treated by an MFM?
Well, ideally, someone sends them to us before they get pregnant so we can review their history and give them advice on how to optimize their health. So, for example, if a diabetic is really out of control, we could help her get her blood sugars under control before she gets pregnant. But more often, they're referred to us after they're already pregnant.
And do MFMs treat those patients directly or in consultation with other physicians?
Well, usually we treat them directly, but there are some complex conditions that require consultation with other practitioners. For example, if someone had some very complicated cardiac disease, I would work along with their cardiologist to make sure that the care was appropriate.
These pre-existing underlying conditions, do they increase the risk of morbidity and mortality during pregnancy?
Yes.
Can many of these conditions be treated during pregnancy effectively?
Yes.
Are there conditions that if a patient has the condition, they just should not get pregnant?
Unfortunately, yes.
Could you give an example?
Well, for example, pulmonary hypertension. Those patients are severely compromised, and the stress of pregnancy results in an incredibly high maternal death rate.
You have a pulmonary hypertension patient who does get pregnant, what is your recommendation for that patient?
Well, I would explain the physiology to her if she didn't understand it and lay out the risks as accurately as I could. But the patient has to agree to that treatment. If the patient did not accept my advice, then I would give her as much support as I could.
What would your advice be?
Well, I would advise to terminate a pregnancy in that situation.
Have you had a pulmonary hypertension patient who became pregnant and decided to remain pregnant rather than terminate?
Yes, I had a young patient in Iowa who was only 22 and had pulmonary hypertension, and I advised her to terminate. She chose not to. We admitted her to the hospital, and she died at 24 weeks.
How old was she?
22.
Are there conditions where you cannot say that a patient is likely to die, but where being pregnant may seriously compromise their health?
Yes.
Can you give some examples or categories of what those conditions would be?
Well, any condition that could have deleterious effects on your major organs, heart, lungs, kidneys, for example. So diabetes. You know, it's very, very hard to control. Diabetes does do damage to your kidneys, and pregnancy puts incredible stress on your kidneys. So that could result in loss of kidney function, as an example.
And short of death, what does loss of kidney function, what can that do to a patient?
Well, it significantly changes her life after pregnancy and the life of her children and family. You know, if someone loses kidney function, they're on dialysis, which is labor intensive. They need a kidney transplant. Or if they don't quite qualify, they just may be, you know, ill and unable to participate in family activities. And that would apply to other major organ damage as well.
So for these pre-existing underlying conditions that pose a serious risk to the patient's health, is termination within the standard of care for those conditions?
Yes.
If a patient chooses not to terminate, you said serious organ damage is a potential outcome.
Yes.
Could that shorten the patient's life?
Yes, significantly.
We've already discussed in some previous testimony extensively some of the pregnancy complications, which I think was the second category, correct?
Right.
So I'm not going to spend a lot of time with you on those today, but I do briefly want to ask you a few questions about PPROM. What is the standard of care for pre-viable PPROM without symptoms of infection?
To offer pregnancy termination.
To if they're going to go through condition after condition after condition, if there's no evidence of people actually before this court who need to be treated with those conditions, it's irrelevant.
All right, understood. And I'm going to overrule the objection. I assume that we're looking at some relatively limited universe of conditions you intend to cover, and I understand your argument that that's not a proper means of pursuing the theories that are being pursued, and ultimately a final ruling will be made, I suppose, at the end of the case on whether that is or isn't a permissible means of pursuing the theories at issue, but I'll allow the evidence to come in. All right. If you recall the question, you are welcome to answer it.
I can repeat the question for you.
Sure.
What is the standard of care for a pre-viable PPROM without symptoms of infection?
To offer pregnancy termination versus expectant management.
And is the standard practice to offer termination upon diagnosis of pre-viable PPROM or to wait for signs or symptoms of infection?
No, at the time of diagnosis.
And why?
Well, because the major complications that can occur in that gestational age are infection and bleeding, and we're very bad at predicting either of those. Because of the anatomy of the uterus and the isolation of the fetus from the mother's circulation, you can have a really serious infection developing in the fetus and in the placenta and the tissues before the mother even has a fever. So although we send women home with instructions to take their temperature and pay attention to symptoms, more often than not, by the time they realize that they have developed symptoms, they're very sick.
So why can't you just provide antibiotics to either prevent infection or treat an underlying infection?
Well, the great thing about pregnancy is also the problem in this situation. The great thing about pregnancy is that the mother can tolerate carrying a fetus who's gets half its genetic material from the father and therefore is not matched to her. It's like having an organ transplant that's not matched to you. But because the fetal and maternal circulations never meet and the fetus is isolated in its sterile, water balloon, and the mother's immune system is depressed, she'll tolerate that fetus. Now, when she gets pregnant, however, her immune system is depressed and the fetus is separate and could develop this huge infection without the mother really knowing it. And we decide to treat the mother. The other thing that protects the fetus is that a lot of stuff doesn't cross the placenta. So we can, for example, I can treat the mother with a medication that might hurt the fetus, but because it doesn't cross the fetus, the placenta is okay. Well, antibiotics don't really cross the placenta either. So now it's an isolated fetus with its own infection, and we can't get drugs into its circulation.
So if you have pre-viable PPROM, that means that the patient is losing amniotic fluid, correct?
Right.
How does the loss of the amniotic fluid?
I'll object as leading.
Why don't you restate the question?
What happens to the amniotic fluid when membranes rupture?
It leaks out continuously.
How does the loss of amniotic fluid affect the fetus?
Well, the problem is that the time from about 16 weeks to 28 weeks is a crucial time for lung development. And in order for the fetal lungs to develop, they have to be able to breathe in the amniotic fluid, which is largely fetal urine. So breathing in the fluid helps expand the lungs. Expansion of the lungs helps the chest to develop. And none of that will happen if you don't have enough amniotic fluid. So even if someone could make it to a peri-viable age after PPROM, if they've been ruptured from, had an early rupture, there's a high likelihood that the fetal lung development won't be sufficient to support the baby.
I want to turn now to the third category of conditions that you said that MFMs treat, which are fetal conditions. Mm-hmm. Are there some fetal conditions that MFMs can treat prenatally?
Yes.
Can you give the court an example of that kind of treatment?
Well, since we just talked about PROM, one condition is when the urethra, the tube that drains the bladder, doesn't develop or is blocked, then urine can't escape out of the bladder. Urine backs up and that could damage the kidneys, but more importantly, without urine coming out of the bladder, there's no fluid around the baby. So even though the lungs have the potential to develop normally, they won't develop. We can fix that by putting a little catheter, using ultrasound guidance to put a catheter into the bladder, so one ends in the bladder and the other end is coming out, diverting that urine into the amniotic cavity. That allows normal development of the lungs to occur, and then the baby can have the urethral problem fixed surgically after birth.
Would that work for a PPROM patient?
No, because the fluid will continually leak out.
So back to the fetal conditions. Are there fetal conditions that MFMs cannot treat?
Yes.
And out of all of the conditions out there, can you treat most or most not treatable? Most
not treat.
So I want to focus in on lethal fetal diagnoses.
Okay.
Does lethal fetal diagnosis have a medical meaning?
It means incompatible with life outside the womb beyond a few hours or a few days.
And does it also does it also include situations where the fetus may not survive to birth?
Action leading.
I'm sorry, where the end of the question, the fetus may not survive what?
To birth.
All right, overruled. You can answer.
Yes.
How do you diagnose lethal fetal conditions?
Well, we don't have a lot of diagnostic tools, but ultrasound is a major tool. So if we identify certain malformations, they're clearly lethal, and we also have various genetic testing abilities.
How accurately can you diagnose a lethal fetal condition?
Well, some of the most common ones are not that hard to diagnose. They're obvious on ultrasound.
And then can you just describe the genetic testing that could be done to identify other lethal conditions?
Sure. Well, if I think say I see one structural abnormality. Maybe I see a cleft lip and palate. The most common cause of cleft lip and palate is just that it's an isolated problem that can be fixed surgically, but there are also a number of genetic conditions that include cleft lip and palate, and those conditions involve other abnormalities that you can't see with ultrasound, abnormal brain function, abnormal liver function, stuff like that. And so if I saw a patient with that kind of condition, I would offer her the option of genetic testing to see if we could identify a syndrome so that I could give her more information.
You mentioned that some diagnoses can be made based just on the ultrasound. What diagnoses are those?
Major structural abnormalities, for example, anencephaly, where the brain doesn't develop above the brow line. Holoprosencephaly, where the brain itself is malformed. Instead of being in two halves, it's one big brain with a hole in the middle. Very serious spina bifida, spine defects, and some others can be seen obviously with ultrasound alone.
What about hydrops?
Hydrops is very obvious on ultrasound. You see fluid in the fetal tissues, and that has various causes, but none of them are compatible with life.
What about heart conditions?
There's some very severe heart conditions. Hypoplastic left heart is the most common thing we see. We can ordinarily see all four chambers of the heart on ultrasound in that condition. The left ventricle, the ventricle that pumps blood to the body, is so small that it's very hard to see. And you can actually use Doppler technology to look for blood flow and see if there's any flow coming out of that side of the heart. So that's when we can see with ultrasound alone.
Dr. Winstrom, what is the standard of care for a patient who receives a lethal fetal diagnosis?
To offer pregnancy termination or expectant management, unless there's diagnosis as one that would affect their own health, and then I would strongly recommend for pregnancy termination.
How do you counsel patients about their options?
Well, it's hard. Usually I take them to a separate room and ask if they need anything, because just giving them something they can make a decision on gives them a sense of control. Then I sit down and I explain the condition as carefully as I can, explaining it in language they would understand. If they have a family member with them, I talk to both of them, tell them what I know about the condition, what the likely outcome of the condition is going to be. And once they've digested that, I talk about what our options are.
And how do you walk the patient through the options?
Well, pregnancy termination, if I'm pretty sure this is a lethal condition, can be done. We can talk about the options for the way that can be performed. Versus expectant management, which would mean carrying a fetus that's likely to die to term. You have to explain that baby could die in utero, second or third trimester. How would we handle that? If they make it to term, how are they going to handle being in a labor and delivery where everyone else is having a live baby and you're going to have a dead baby? Do you want fetal heart rate monitoring, recognizing you could be listening to the baby's heart slowly dying? Do you not want monitoring? Then you don't know if the baby's alive or dead. What do you want to be done at the delivery? Do you just want comfort care? Do you want some form of resuscitation just on the off chance that something could be accomplished? Who should be there? What's going to happen to the body afterward? It's a long process to decide everything.
If a patient declines termination and decides to continue the pregnancy, how does that complicate the pregnancy?
Well, for example, if the fetus has high drops and it continues to survive, the patient's at risk to develop serious hypertension as a result, so she would be monitored very closely. For conditions that probably are less likely to affect the maternal health, then we just monitor for the standard pregnancy complications, which that patient could have like anybody else. She could develop preeclampsia, she could go into preterm labor, and care for her that way.
Can it complicate the labor and delivery process?
I'm sorry?
Can some of these lethal fetal conditions complicate the labor and delivery process?
Yes. For example, if you carry a fetus with anencephaly to term, it's difficult to get, and they want a vaginal delivery. That's sometimes difficult to accomplish because the part of the brain that's involved in stimulating labor has not developed. So they frequently go post-dates, and it's hard to get them delivered, as an example.
You mentioned before that there are conditions where you would not simply counsel the patient about their options, but you would recommend termination. Is that
Right.
What are some examples of those conditions?
Well, I mentioned high drops. That's the fetus has extra fluid in all its tissues. That leads to the placenta having too much fluid. That changes the vascular function in the mother. Then the mother can develop severe high blood pressure and eventually preeclampsia at an early age. So that would be a very serious condition.
I want to turn now to the laws at issue in this case. Have you read Idaho's total abortion ban?
Yes.
And have you read the 6-week ban?
Yes.
Do these laws use medical language?
No.
I'm going to focus you in the total abortion ban on the phrase necessary to prevent the death of the pregnant woman. Do you find that phrase clear about which conditions that it applies to?
No.
Why not?
Well, I'm in a field where we're not trained to anticipate death. Our whole training and practice is to not let the patient get close to death. So my ability to predict when death will occur is not comparable to someone that works only in the trauma unit. And it's not clear how urgently or what the timeline is for the death that's about to occur. Do they mean death that's going to occur in an hour or today, or do they mean it's going to shorten her life by 40 years, so she's going to have an early death? And so it's hard to, in my opinion, I would find it hard to know when that law, when I was obeying the law and when I was not obeying that law.
Have you read excerpts from the Idaho Supreme Court's decision in Planned Parenthood versus
Yes.
Idaho?
Yes, sorry.
In that decision stated that there's no particular level of immediacy required for it to be an abortion to be necessary to prevent the death of the pregnant woman, correct?
Right.
Does that clear up your confusion?
No, I think that makes it more confusing.
Why?
Because there's so many pregnancy complications that can significantly shorten a patient's life. She may survive the delivery, she may die a year later, she might die at a very young age because of things that happened during the pregnancy. So the sense of immediacy doesn't really help me.
I'm going to turn to Idaho's 6-week abortion ban. And I'm just going to read to you Idaho Code 188802 subsection 6. Have you reviewed that?
Yes.
And it states the fetal heartbeat, when detected, presents a clearly identifiable point at which the preborn child in the womb has a greater than 95% chance of survival when carried to term. Is that medically accurate?
No.
Why not?
At that gestational age, the heart itself hasn't even completely formed, never mind other, structures. And as we've sort of discussed, a whole catalog of abnormal things and adverse outcomes can occur during pregnancy. So that doesn't even confirm that the fetus has normal anatomy, that pulsing that you can see here at 6 weeks. And then that doesn't take into account all the problems that can occur, and the most important thing in that fetus's survival, which is the mother. So finding a heartbeat at 6 weeks doesn't tell me that the baby's lifeline, the mother, is going to help it get to term in 95% of cases, because in my experience, that's not true.
You're aware that the 6-week ban uses the phrase reasonable medical judgment?
Yes.
Do you have any concerns with that standard in the context of a criminal law?
Yes.
What are your concerns?
I think as a whole, OBGYNs are extremely risk averse for many reasons, not least of which is that we can be sued until the baby we deliver reaches the age of majority, which is either age 18 or age 21. So I think we bend over backwards to provide care that's as evidence-based as possible, which is why ACOG is so helpful in their educational activities and their bulletins. Yet, things go wrong. We do get sued, and we rely on medical experts to decide whether or not what we did was wrong or right. In this situation, it's not clear to me who will be deciding what's wrong or right. It's hard enough to defend a doctor who's been accused of medical malpractice when he's being judged or she's being judged by her peers. But in this situation, who is going to decide that I didn't use reasonable judgment? Is it going to be somebody with no medical training? Even people with advanced education, if it's not in medicine, would find it hard to decide if I did the reasonable thing, especially in these extremely complicated situations.
If you are sued for malpractice and you lose that malpractice case, what's the consequence?
Well, my insurance would pay out and
About the civil injunctions, the state of Idaho has no authority to enforce the civil part, and so that's irrelevant.
Is that where you're heading? I assumed that perhaps where you were going was contrasting the stakes in civil malpractice contexts versus violating the criminal provisions of the statute.
Right.
All right. I'll permit you an answer to finish your answer.
If you are sued in malpractice and you lose the malpractice case, what are the consequences for you?
My insurance company will usually pay out a financial settlement, but I'll be able to continue practicing medicine.
Do the stakes of a criminal law, would they change your analysis when determining whether to provide care under the law?
Yes, because in this law, I don't know who's going to be judging my practice, but I would be put in jail, lose my license. That would change my life. And even if I was able to get out of jail, that doesn't stop the fetus's relatives from suing me. Because if I understand the law correctly, anybody involved in or related to this fetus can sue. So it would essentially end my career and ruin my life, I think, if that happened.
Would you practice as an MFM in a state with a ban in place like Idaho's total abortion ban?
No.
Would you practice as an MFM in a state with a ban in place like Idaho's 6-week abortion ban?
No.
I'm going to turn now to the 4 patient plaintiffs in this case. Have you reviewed their medical?
Your Honor, because she has not been disclosed as an expert witness for their case in chief on forming an opinion on the 4 plaintiff patients, so it violates the court's scheduling order.
All right. Is that true?
Your Honor, this is a topic that we in the pretrial conference you said that we would be allowed to introduce topics that were disclosed in the rebuttal reports, which she did discuss the 4 patient plaintiffs and the rebuttal reports after Dr. Scott reviewed their records. I'm not going to ask questions like asking her to criticize Dr. Scott's testimony that hasn't been presented yet, but in your pretrial conference ruling, you did allow us to introduce topics that were disclosed for the first time in the rebuttal reports in order to simplify the presentation of the evidence.
All right, so I guess I had understood the objection to indicate this just was not a topic on which there was a disclosure.
There was a disclosure in the
Your
rebuttal.
Honor, there was not. The court's scheduling order required them to disclose all expert witnesses to testify in their case in chief by a certain date. And then Rule 26B4A requires that a proper disclosure include a complete statement of all opinions to be expressed. Their initial disclosure from Dr. Wenstrom had absolutely nothing about any of the 4 plaintiffs on this case. So her rebuttal report did, but that's only rebuttal. That violates the court's order to have her schedule now, or to testify on that now. The court's scheduling order required them to disclose all opinions to be used in their case in chief by a certain date, and they did not do that.
All right, understood. Are you disputing Mr. Herron's assertion that the matter was covered in the rebuttal disclosure?
I am not disputing that. It was covered in the rebuttal disclosure.
All right, and are you contending that that it's not proper rebuttal to the opinions of Dr. Scott that you disclosed?
So what I'm contending is that the court's scheduling order requires all expert witnesses testify to support a claim to be disclosed by February 12th, 2024. They did not disclose Dr. Wenstrom as an expert witness to support those claims. This is their opportunity to present evidence to support those claims. This is not their opportunity to rebut our expert testimony. And so they are putting the cart before the horse. If they want to rebut Dr. Scott's testimony, they need to wait until she testifies. But at this point in time, it is their opportunity to support their case, and they have not disclosed Dr. Wenstrom as an expert on those plaintiffs' conditions. And so they are violating the court's scheduling order by presenting her testimony on those pregnant plaintiffs.
All right. So you said, Mr. Herron, something to the effect that the witness is, you're not going to ask her to rebut testimony by Dr. Scott that has yet to be presented.
I'm not going to ask her to respond to specific criticisms or specific things that Dr. Scott stated in her expert report. For example, we would wait on that until after she testified. But in your pretrial conference ruling, you said that we could, and I believe yesterday you were saying we could discuss topics that were disclosed in the rebuttal as because that, to simplify the presentation of evidence. So that's where I'm going here. I'm not going to a specific, Dr. Scott said this, what's your response? That's not going to be my question. These are topics that were disclosed, and these were clearly a part of her rebuttal expert disclosures.
There was no topic disclosed that she would testify on the 4 pregnant plaintiffs. In fact, she specifically testified at deposition that she had not reviewed any of the plaintiffs' medical records prior to her initial report. It was just simply not mentioned.
I understood, and I don't think Mr. Herron is contending it was mentioned in the initial report. Dr. Scott's report, I gather, covers opinions related to the 4 patient plaintiffs.
Correct.
And in rebuttal to those opinions, which have yet to be presented during the trial because it's not yet defendant's turn, you disclosed opinions by Dr. Wenstrom.
Correct.
All right, and so let me ask this: Are you expecting to call Dr. Wenstrom after we hear from Dr. Scott?
It depends on Dr. Scott's testimony, exactly what she says and what the court allows her to testify to. I will say Dr. Winstrom, again, in the pretrial conference, you allowed any rebuttal testimony to be done remotely, so she won't be here in person for her rebuttal testimony. If she is called, we may not call her at all, depending on what Dr. Scott says here in person and what the court allows her to say.
All right. Well, I guess what I am interested in doing is trying to avoid, in this context, as much as possible, witnesses taking the stand more than once. And I am more concerned here with whether there was or wasn't a proper disclosure than at what point in the trial I hear any particular evidence. And so, as I understand the objection is not that there wasn't a disclosure made; it's that it wasn't part of the initial disclosure and therefore shouldn't be part of the case in chief. And while that indeed reflects the usual course of how cases are presented, it seems to me that there is a greater ability to organize the presentation of evidence with a view to promoting efficiency in the context of a bench trial than might be proper in the context of jury trial. I don't have a problem with trying to hear this evidence now in hopes that Dr. Wenstrom can complete her testimony without having to be recalled at some later stage. So I'll permit the line of questioning.
And Your Honor, if I may ask that you not consider it as part of their case in chief, and that it only be considered for rebuttal purposes if it gets to that point.
I see. And so what you're suggesting is that for purposes of some Rule 50 motion that might be made, that this not be deemed part of the plaintiff's case in chief. What do you think about that, Mr. Herron? That seems fair. So ordered. All right. And it was, if you are at some point with Dr. Wenstrom still on the stand, starting to, I guess, veer back into originally disclosed testimony, let me know so we can kind of have the clearest demarcation we can have about as far as what is going to be deemed case in chief evidence and what is not.
Dr. Wenstrom, have you reviewed the medical records of the 4 patient plaintiffs in this case?
Yes, I have.
I want to first ask you about Jennifer Atkins. Based on your review of her medical records, what conclusion do you reach about her diagnosis?
Her fetus had Turner syndrome and high drops.
What does Turner syndrome mean?
It's a female fetus who inherits only one copy of the X chromosome instead of 2.
And you've briefly discussed high drops. Could you say again what high drops is?
So it's a severe complication, really an abnormality of the lymph system. Lymph fluid collects, in this case, a huge sac of fluid at the back of the neck, which was lymph fluid draining from the brain that wasn't connecting to the thoracic duct, and significant tissue edema. So high drops is abnormal fluid in at least 2 body cavities or body locations.
I'll just remind you to speak a little bit slower for the benefit of the court.
I'm so trying. Sorry.
Was this diagnosis a lethal diagnosis?
Yes.
Were there risks to Mrs. Atkins from continuing the pregnancy?
Yes, I think we discussed earlier how this abnormal accumulation in the fetal tissues leads to abnormal fluid accumulation in the placenta and somehow changes vascular reactivity in the mother to lead to severe hypertension and features of preeclampsia, and including edema, which is why it's called mirror syndrome. The fetus is puffy and the mother's puffy.
Was pregnancy termination within the standard of care for
Yes.
Mrs. Atkins?
Yeah, I'm sorry, yes.
Kayla Smith, based on the test results and the medical records that you reviewed, What conclusion do you reach about her diagnosis?
The fetus had a non-survivable fetal heart defect called hypoplastic left heart syndrome.
And what does that mean?
There are 4 major chambers in the heart. The left ventricle is the chamber that pumps blood to the rest of the body, and that chamber essentially didn't form. It was very small and it didn't move. And when they looked with Doppler flow, there was no blood coming out of that chamber.
Could that have been treated with fetal surgery?
No.
Was this a lethal fetal condition?
Yes.
Objection, leading. Move to strike. Both of the last questions were leading, so move to strike the answers on both of those.
Was termination within the standard of care?
Yes.
Jelaine St. Mitchell, based on the medical record that you reviewed, what conclusion do you reach about her diagnosis?
The fetus, well, the diagnosis in the record said caudal regression, but I prefer the term sacral agenesis because caudal aggression implies that somehow the lower part of the spine formed and went away, but really didn't form at all. So the lower part of the spine below the sacrum doesn't develop. That means there are no nerves going to the legs, so the legs won't develop and they won't move. But it's also a developmental field defect, meaning that it doesn't just involve the spine and the nerves. It involves all the structures in that developmental area of the body. So there won't be, usually there's not a bladder, so there won't be fluid. And as a result, the chest, the lungs won't develop and the chest will be small. And I believe that was found in this fetus. The kidneys won't develop, often abnormal genitalia as well.
Was this a lethal fetal condition?
Yes.
Was termination within the standard of care?
Yes.
And last, Rebecca Vinson Brown, what was her diagnosis based on your review of the records?
Triploidy.
What does that mean?
That means the fetus has 3 copies of every single chromosome.
Is that a lethal fetal condition?
Yes.
Were there risks to her from continuing the pregnancy?
Yes.
What were those risks?
Well, it's interesting because the placental karyotype is the same as the fetal karyotype. The placenta, therefore, is also triploid placenta, and they're at increased risk of placental detachment and bleeding. These fetuses can develop hydrops. It can cause problems.
Was termination within the standard of care?
Yes.
Nothing further, Your Honor.
All right. Thank you, Mr. Herron. Cross-examination, Mr. Craig.
Yes, Your Honor, and I'd request that I be allowed to conduct a cross-examination on the rebuttal portion after our case in chief is over. And so not do it right now during their case in chief, but wait until after our case in chief is over and do a cross-examination on rebuttal portions at that point.
I guess the problem to me is it defeats the purpose of allowing the testimony to have been done.
And at this point, we don't even know whether it was proper rebuttal because we don't know what the defendant's case was. And so I don't want to be conducting rebuttal on, or cross-examination on rebuttal on things that we don't even know if it was proper rebuttal because we have not presented our case in chief yet or our rebuttal case.
Your Honor, the purpose, I'm sorry. All right. So, Your Honor, one of the reasons that we had requested the ability for Dr. Winstrom and other experts to testify about these topics was because not just for the presentation of evidence to make things more convenient, but also due to the schedules and availability of our witnesses. Particularly, we didn't know until the very last minute that Monday would not be an available trial date, and so we ended up having to, at the last minute, shift some schedules around. So it's a little complicated to do that now.
Well, I guess it seems to me that these are disclosed opinions. The testimony that follows them has been presented, and that knowing what the opinions were, that there is an opportunity to prepare. And I'm not hearing you say you're not prepared. What I'm hearing you say is that essentially that this is just not the order in which things would occur, and you can't assess if it's proper rebuttal if you don't know yet what Dr. Scott is going to say, I guess I'm not adverse to the idea that perhaps the way Dr. Scott's testimony comes in perhaps justifies a second opportunity to cross-examine Dr. Wenstrom. But it seems to me that there is not anything inappropriate about expecting you to undertake cross-examination on the testimony that has been rendered, with the potential possibility that you can convince me that circumstances entitle you to some further opportunity on down the road.
Understood.
All right, go ahead.
I will try to be as clear as possible when I'm crossing on the rebuttal as opposed to the...
Appreciated. Thank you, Mr. Craig.
Yes. In fact, I'll just start with the cross-examination on the rebuttal first before I go into the other parts.
Okay, that makes sense to me.
All right. Dr. Wenstrom, you were not the treating physician for Dr. Atkins, is that correct? Or I'm sorry,
Correct.
Ms. Atkins.
I'm sorry, that's correct.
And you were not treating physician for Ms. Smith, is that correct?
Yes,
And same would be true for Ms. St. Michelle. You were not her treating physician.
right.
And you were not the treating physician for Ms. Vincent Brown, is that correct?
Yes,
And the triploidy diagnosis for Ms. Vincent Brown, that was a partial molar pregnancy, is that correct?
yes,
And in any of those situations, if the treating physician believed that conducting an abortion, well, actually, let me rephrase the question. Setting aside Ms. Vincent Brown, so the other three, Ms. St. Michelle, Ms. Smith, and Ms. Atkins. If the treating physician had thought that an abortion was necessary to prevent her death, that could have been done here in Idaho, is that correct?
Objection calls for legal conclusion.
I'm not sure that it could.
All right.
And
I'll permit the answer. Go ahead and continue.
Thank you. And is that because you did not find that it would have been necessary to prevent their death?
Well, I think in the case of the hydropic fetus with Turner syndrome, the patient was at risk to be severely compromised and maybe have end organ damage, which would have been legal under one law, but wouldn't have met the criteria for the other law of imminent death. And I think that would have been very difficult.
So you're not asking the question or answering the question that I asked. So for Ms. Atkins, if her treating physician had determined that conducting an abortion was necessary to prevent her death in his good faith medical judgment, that physician could have done an abortion under Idaho's law, correct?
Calls for legal conclusion.
Well, I find that question very difficult to answer for all the reasons I've already explained. I personally find that law and its definition of death to be very difficult to understand. You know, when should the death occur? So I think out of caution, most physicians would have recommended it be done out of state.
Okay, you're still not answering the...
All right. The question is, or the objection is that it calls for a legal conclusion, and it would seem that it does. It would seem that you're asking the witness to opine on whether, in a certain medical circumstance, the law allows or doesn't allow an abortion, which I think would be kind of a standard type legal conclusion. Is that not right?
So the law requires a treating physician to make a determination on whether it's necessary to prevent the death of the woman. She's testifying as an expert witness and has formed an opinion on whether an abortion was part of the standard of care in treating those women. So I think it's perfectly appropriate to ask her a question about whether an abortion was necessary to prevent the death of the women.
Well, I think that's perhaps somewhat different than the question you asked, and if you want to ask her whether whether an abortion under the circumstances presented was necessary to prevent the death, I think you may be permitted to do that. I think if you phrase the question in terms of was an abortion legal or not legal in those circumstances, it seems to then cross over into the line of asking for a legal conclusion. Now, the difference may be subtle because the legal test is necessary to prevent the death. But in any event, go ahead.
So, Dr. Winstrom, for Ms. Atkins, did you make a determination on your review of the medical records whether an abortion was necessary to prevent her death?
No, I didn't.
And for Ms. Smith, did you make a determination on whether an abortion was necessary to prevent her death?
No, I didn't.
For Ms. St. Michelle, did you make a determination on whether an abortion was necessary to prevent her death?
Just to clarify, when I'm saying no, I'm saying I didn't decide whether it would prevent her death or not. I didn't address that issue.
So you're not forming an opinion one way or the other on whether it was necessary to prevent her death?
That's right. Okay. Because I just looked at the record, very limited parts of the record. I didn't talk to the patient. I didn't have a chance to examine the patient or review entire medical history. I looked at a small part of the record that was made available to me.
Your Honor, based on those answers, I'd move to strike all of her testimony on those issues because it's not relevant. The only relevant issue would be whether the treating physician determined that it was necessary to prevent her death. Anything else is not relevant to the claims.
All right. Well, I'm gonna deny that motion. You're welcome to make any argument you want to make and propose findings and conclusions concerning the evidence admitted and whether it ought not be considered or ought to be considered, and if so, for what purposes.
Okay, so I'm going to move on from the rebuttal and go to the cross-examination on the case-in-chief part.
Understood. Thank you.
So, Dr. Winstrom, you've delivered approximately 9,000 babies in your career, is that correct?
Yes. 9,000 plus.
Over 9,000 babies. And you've treated tens of thousands of pregnant women throughout your career?
Yes.
And for much of your career, you've specialized in very complicated pregnancies?
Yes.
And I believe you testified that you were considered a maternal fetal medicine specialist, is that correct?
Yes.
And the maternal fetal medicine specialist, or the specialty, it's a specialty whose goal is to help complicated pregnancies successfully deliver a viable baby at term, is that correct?
That's right.
In fact, much of your career has been dedicated to determining how to treat unborn babies to allow them to survive and have better lives, correct?
Yes.
And as part of your career, you've provided fetal blood transfusions to help the babies survive, is that correct?
Yes.
So why would you do those fetal blood transfusions?
Well, even though I testified that the maternal circulation and the fetal circulation are separated, some fetal cells do get into the maternal circulation, and if the baby's blood type is different from the mother's, she can form antibodies that do cross the placenta and destroy the fetal red blood cells, so the fetus can become extremely anemic and die of hydrops, essentially, caused by severe anemia. So in that situation, a blood transfusion is life-saving.
Life-saving for what?
The fetus.
So you do the fetal blood transfusion to save the baby.
Right.
And that's a situation you just testified of hydrops that can be treated with a blood transfusion, is that correct?
Yeah, I believe I said that the vast majority of hydrops cases for other reasons cannot be treated. This is the one that can be treated.
And you've done other conditions to save the life of the babies as well. For example, putting a shunt in a bladder that had blocked urine to be able to save the baby. Is that correct?
Yes.
And what was the purpose of that?
Well, to allow the lungs to develop so that the baby would be able to survive after birth and undergo surgery to correct the bladder problem.
And you, throughout your career, would also treat the unborn babies by putting in chest tubes in certain circumstances. Is that correct?
Yes.
And what was the purpose of that?
Well, there's some conditions where fluid builds up in the chest and compresses the lungs, and if the fluid remains there, then the lungs cannot develop. So putting in a chest tube to divert the fluid out of the lungs allows the lungs to develop normally.
And is that also a life-saving treatment for the baby?
Yes.
You're also able to treat the unborn babies by putting medication directly into the fetus. Is that correct?
Yes.
And why would you do that?
Well, in some cases, fetal arrhythmias are so out of control that the fetus has started to develop hydrops, and in that case, some medications, let me back up, some medications used to treat fetal anemia can be administered to the mother and reach the fetus, but if the fetus has had the arrhythmia for so long that they're starting to become hydropic, then the medication, I'm sorry? Oh. By crossing the placenta, right. But if the arrhythmia has persisted for so long that the baby is starting to retain fluid, like developing hydrops, then the medication won't cross the placenta, so you have to give it directly to the baby.
And that would also be life-saving treatment for the baby?
We hope so.
And when you were at Vanderbilt, you participated in research studies and performed research on performing surgeries on unborn children. Is that correct?
Yes, one research study.
And can you briefly describe that?
Well, spina bifida results in paralysis of all, and malfunction of all the organs below the defect. And to back up, spina bifida is a situation where the vertebrae, some vertebrae in the spine don't completely close. So if you think of the vertebral column as beads on a string, the beads are the vertebrae and the string is the neural tube, the fibers, the neural cord. If the beads don't form or the vertebrae don't completely close, then all that neural tissue is exposed to amniotic fluid. So the first hit is that the spinal cord is open, and the second hit is that the exposed nerves are damaged from exposure to the amniotic fluid. So this was a project that proposed to close the defect in order to avoid the damage from exposure to the amniotic fluid. So we would, after extensive studies, open up the uterus, take out the fetus. The neurosurgeon would close the defect or put a membrane closure over the fetus, and then we'd put it back in.
How old were the unborn children at that time in terms of weeks of gestation?
Generally 22 to 25 or 6 weeks.
And the purpose of this was to save the lives of the baby?
Well, mostly to save function for the baby, because there's the severity of outcome in a spina bifida case relates to where in the spine the defect occurs. If the opening in the spine is very high, you probably can't save the baby because all the nerves that make the diaphragm move, make the respiratory muscles move, all those things will not function. But for lower defects, doing this surgery may give the baby more function. In fact, the outcome of the study was whether they could ambulate or ambulate with assistance, and other things were evaluated as well. The last thing is a lot of spina bifida babies develop extra fluid in their brain, which can cause significant problems, and so it was hoped that this surgery would prevent that from happening.
So all of these procedures on the unborn babies that we just described, the goal would be to save the life of the unborn child or to help them function better after the baby's born. Is that correct?
Yes.
And so when an OBGYN or any doctor treats a pregnant woman, there are two patients, is that correct?
Yes.
And one of the patient would obviously be the pregnant woman, correct?
Well, she's a major patient.
And then the other patient would be the unborn child, correct?
Yes.
And I suppose if they're twins or triplets or some other, then there would actually be more than 2 patients, correct?
Yes.
And when you treat a pregnant woman, you must assess each patient's unique situation. Is that correct?
Which patients are you referring to?
Just in general, when you treat a pregnant woman, you must assess the patient's unique situation. Is that correct?
Yes.
And each pregnancy is different. Is that correct?
Yes.
And for each pregnancy, physicians must make complex, individualized determinations as to how to treat the pregnant woman based on that woman's particular circumstances, correct?
Yes.
And in assessing each patient's unique medical situation, doctors must be able to exercise their reasonable medical judgment, correct?
Yes.
And in assessing each patient's unique medical situation, doctors must take the facts of the case, look at the case, and then make a good faith determination as to what type of care is required. Is that correct?
Well, I'm not sure good faith judgment is required. I think medical judgment is required.
I want to hand you your deposition. I don't believe you have any. Thanks. Could you please turn to tab 31, that is Exhibit 1031.
Well, I don't have a tab 31. This only goes up to 30.
Okay, let me get you the next one. I apologize.
Okay. Okay.
It should show that that is a copy of your deposition that you did in this case. Is that correct?
Yes.
Can you please turn to page 46? So there's 4 pages on each page, and so look at the one that would say page 46.
Okay.
Could you please read page 46, starting at line 22, through page 47, line 2?
Silently.
No, you can read it out loud, please.
So 22 is your question. So they take the facts, they look at it, they use their training and experience and exercise their medical judgment in terms of recommending a treatment and then following through with that treatment? Yes, that's right. I'm reading all the way to what? End of 47?
I had asked you to read through line 2, so that is
Okay.
fine. And then could you also read on page 46, lines 12 through 16?
Question. That's why doctors need to be able to take the facts of the case, look at the case, and then, make a good faith determination as to what type of care is required? Yes.
And this is something that doctors do in every case that they treat, correct?
Yes, although at the time I didn't realize the legal definition of good faith versus medical judgment. So that's why I'm answering different today. And I don't think the average doctor would understand that difference either.
And it's important for legislatures to be able to allow doctors to be able to make their good faith medical judgment, correct?
I'm having trouble answering that question because I feel like good faith medical judgment is a legal term. It's not really what we say in medicine.
Could you please, on deposition, on page 47, Read lines 3 through 6.
It's the same question. And you said it's important for legislatures to allow doctors to be able to make these good faith medical judgments? Yes. And as I'm testifying now, I didn't really understand the legal definition between that term and the other term.
Lindstrom, I just asked you to read the deposition.
I'm sorry.
So thank you. Pregnancy by itself can pose serious risk to a pregnant woman's health and life. Is that correct?
Yes.
And carrying a pregnancy to term and the delivery itself can each pose risks of severe morbidity and mortality, correct?
Yes, in some situations.
In fact, the delivery itself can be life-threatening. Is that correct?
It can be.
Now, the term morbidity, that refers to harm from disease or injury. Is that correct?
Yes.
Abortions also carry risk to the mother. Is that correct?
Yes.
And women can actually die from an abortion. Is that correct?
It's theoretically possible, but it's very rare.
But women do die from abortions. Is that correct?
Yes.
And fetuses of certain age can feel pain, correct?
Yes.
In your opinion, that's from approximately 24 or 25 weeks of gestation or later, is that correct?
Yes.
How would you define an emergent medical condition?
It's a condition that requires immediate treatment in order to preserve the life or the function of the patient.
Now, you went through some specific situations with plaintiff's counsel, so let's talk a little bit about that. So ACOG, you testified you were a member or in the leadership with ACOG, is that right?
Well, I had various roles in ACOG, yes.
So ACOG, other organizations have not made a list of conditions that might require ending a pregnancy, is that correct?
Right.
And that's because ACOG's opinion is that there are so many, correct?
Well, not only so many conditions, but so many unique permutations because each patient is different.
But you disagree with that opinion, correct?
I'm sorry?
You disagree with that, though, correct?
I disagree with ACOG?
That there are so many conditions that it's impossible to list them all. Is that correct? You disagree with that?
No, I agree with that. I just added something to it.
Okay. But you actually believe that there are not that many conditions where whatever is wrong with the mother requires ending the pregnancy, correct?
I think there are any number of conditions that can lead to any number of maternal conditions that could result in recommendation to end the pregnancy, but a lot of those are rare. So there are a lot. We just talked, but I'm most familiar with the ones that occur more commonly.
Could you turn to page 22 of the deposition, please? Page 22, so I meant page 92.
Okay, I'm on page 22.
Yeah, I misspoke. Could you actually go to page 92, please?
Oh, 92. Okay. Okay.
So I'd like for you to read a portion of your answer, just lines 2 through 4 on page 92, please.
There are not that many conditions where whatever is wrong with the mother requires ending the pregnancy. Do you want me to continue?
No, that's all I needed. Thank you. So let's talk about some of the specific conditions. You mentioned Turner syndrome. So some babies with Turner syndrome do survive to a live birth, correct?
Well, that's a fetal. Now we're talking about fetal conditions?
Yes,
Okay.
that is a fetal condition, but
some do survive, but the 98% do not.
and some will survive after birth as well, correct?
Yes.
Let's talk about preeclampsia. In many situations, preeclampsia can be treated without an abortion, correct?
Yes,
In fact, if the baby's at term, you just deliver the baby, correct?
yes.
Objection outside the scope.
Your Honor, there are lots of questions about the standard of care and treatment of specific conditions. I think this is definitely within the scope.
I did not ask her about preeclampsia.
I don't recall questions on the topic of preeclampsia. Were there any?
So whether there were topics on the specific questions, I don't think matters whether it's within the scope, because they ask questions about broad conditions and what's within the standard of care, and they had all these different categories, and so I'm asking questions about different types of conditions that women may be faced with. That is well within the scope of what they asked on direct.
Your Honor, the only pregnancy complication that I asked Dr. Winstrom about was PPROM.
In the objection, it does seem to me to be outside the scope. You can continue.
PPROM can often be treated without an abortion, correct?
Well, it depends when it occurs.
So if it's at least 25 weeks in gestation and there are no signs or symptoms of infection, then the patient is generally hospitalized and receives expectant management, correct?
Yes, that's correct.
Even before 25 weeks, PPROM can be treated with expectant management, correct?
Under certain conditions, that's correct.
And you testified being involved with the Society for Maternal Fetal Medicine, is that correct?
Yes,
And I believe you said you started their publication efforts, is that right?
yes,
And they just recently published a bulletin that talked about PPROM. Are you familiar with that bulletin?
yes,
And in that bulletin, they determined or reported results of a study that of women who chose expectant management with PPROM prior to 24 weeks of gestation, 40% of the women had no maternal morbidity, correct?
yes.
Placenta accreta spectrum disorder can also be treated without an abortion, correct?
Objection outside the scope.
I don't recall questioning on that topic either. This is just another iteration of the same sort of scope objection and dialogue we had a moment ago. Is that fair to say?
Yes, Your Honor.
All right, I'll sustain that objection as well.
So, Your Honor, I'm going to ask the questions just to preserve the record, understanding that they'll likely be objected to, but I'm going to ask the questions.
Oh, okay, understood. I don't have a problem with that, either that, or I suppose you could make a proffer of which all topics you want to explore that you think are essentially within the bounds of the other rulings, and we can deal with it that way. So, whichever seems to you to be, I suppose, more expedient. So,
I'll just ask the questions.
all right.
So, Dr. Wenstrom, for certain types of hemorrhage, pregnant women can be treated without an abortion, correct?
Yes,
And for HELP syndrome, that can also be treated in some situations without an abortion, correct?
yes,
I guess if he's asking the questions, I'm expecting you to object if you are.
Yes,
if you
objection
consider
outside
them
the scope to that.
objectionable.
Yes, objection outside the scope.
All right, so I think there was confusion on the last two questions about whether Mr. Herron was expected to object or not. So you're wishing now to lodge an objection on as to both of those questions.
Yes, Your Honor.
All right, so those objections will be sustained along the lines with the prior ruling. The testimony given on those in response to the last two questions won't be considered.
So, and then, Your Honor, I'd also raise the point that at the pretrial conference, the court did say that you would not be enforcing the scope of direct rules so that we could be more efficient. So this seems to go against that ruling as well.
All right, so I did say that, but ultimately, what that was intended to do was to allow you to explore any topics that you otherwise might properly explore with a given witness, irrespective of what portion of the trial it's happening in. Now, this witness has been called to as an expert witness to give testimony on certain topics, and it would seem to me that whenever her testimony is being given in the course of the trial, whenever you're cross-examining her, her testimony is properly limited to the subjects on which she's been disclosed as an expert. Now, you're certainly free to ask questions that undermine opinions she has given, but not to effectively, I guess, convert her into your own expert by asking her questions on topics that she's not a disclosed expert to cover.
She was a disclosed expert on these types of topics, and in fact, these were explored in quite some detail at her deposition.
All right. Well, I don't know how to respond to that, but ultimately, and perhaps I didn't explain it very well, but ultimately, when it comes to an expert witness, it seems to me that the calling party has a measure of control over the scope of the testimony that is going to be offered. And to the extent you're exploring topics on which the plaintiffs have manifested an intention not to introduce testimony from this expert at trial, that a scope limitation on cross is proper. All right.
Thank you. Well, again, I'll continue to ask the questions, expecting objections.
Understood.
So hyperemesis gravidarum, that means uncontrollable vomiting, is that correct?
Objection.
And with this one, Dr. Corrigan directly talked about and testified about hyperemesis gravidarum, so it's certainly appropriate to ask this expert questions about that as well.
It's outside the scope of the direct examination of this expert.
All right. I'm going to sustain the objection.
And you can treat gestational diabetes without performing an abortion, correct?
Should I answer that one?
They did ask about
Yes, you
gestation.
can.
Let me rephrase the question. I apologize. I think I was talking over the top of you. Gestational diabetes can be treated without performing an abortion, correct?
Yes.
And these conditions that we talked about, would you consider all of them to be emergent medical conditions?
The ones we talked about are including the ones that we didn't talk to because of objections. Yes, I guess.
So you talked about fetal lethal conditions during your testimony. So let's talk about that. What is aneuploidy?
Aneuploidy
Sorry,
is...
what was the question? I'm sorry.
What is aneuploidy?
Aneuploidy is the inheritance of an abnormal number of chromosomes.
And there's several different types of aneuploidy, correct?
Well, there are many pairs of chromosomes, and any of them can be involved.
And aneuploid infants can survive pregnancy and be born alive, correct?
Well, it depends on the aneuploidy.
So some aneuploid infants can survive pregnancy and be born alive, correct?
Yeah, very small proportion of all aneuploidies.
And you did a study on the efficacy of a multiple marker screening test with elective amniocentesis for detection of aneuploidies in women 35 years of age or older, correct?
Well, yes, I did.
And this test study that you did, the test you were testing only detected 61% of the aneuploids, correct?
That was the case back then.
And of those 61% detected, what percentage of the babies in that study were aborted?
I do not remember.
And of those aneuploidies that you did not detect, those with trisomy 21 had a 73% chance of surviving to term, correct?
Yes.
Those with trisomy 18 had a 33% chance of surviving to term, correct?
If you're quoting me from my study that I wrote 35 years ago, I'll just assume that you're quoting it correctly.
I have a copy of the study I can provide to you if you want to see the study to confirm.
No, I'm just amazed you looked it up. That's okay, I believe you.
Those with trisomy 13 had a 67% chance of surviving to term, correct?
To term, yes.
And not all aneuploid infants who are born alive die immediately, correct?
Well, it depends what you mean by immediately and which aneuploidy you're talking about.
Well, that was one of the statements you made in that study, that not all infants with aneuploid who are born alive die immediately.
May I see the study?
Absolutely.
Perhaps this might be a good moment to take the morning break, unless you're just within a couple of minutes of wrapping up.
That would be a good time to take a break. That's fine. Thank you.
All right, understood. We'll take 15 minutes. We'll be in recess. You may resume your cross-examination of Dr. Wenstrom, Mr. Craig.
Thank you, Your Honor. Dr. Winston, prior to the break, we were talking about study you published on fetal aneuploidy. And I believe the question that I had asked you was that not all aneuploid infants who are born alive die immediately. Is that correct?
Yes, but you quoted statistics. You quoted statistics that actually weren't part of my study.
Well, you wrote in the study that not all aneuploid infants who are born alive die immediately.
That's true.
So those are your words, not mine, correct?
Yes.
And in fact, in the study, you reported that those with trisomy 21 have an 80% chance of living past 1 year, correct?
That was quoting two other studies that were done in the 1980s. So I would have to review, to see if that's still true today, I would have to review those studies.
And when you wrote this report, you reported that those with trisomy 13 had an 18% chance of living past 1 year, correct?
Yes, quoting another study.
And those with trisomy 18 had a 10% chance of living more than 1 year, correct?
Again, in those other studies, that's what they reported.
But you consider trisomy 18 and trisomy 13 to be lethal, correct?
In most cases, yes.
You counsel pregnant women that trisomy 18 and trisomy 13 are lethal, correct?
Yes.
What is a genetic non-invasive prenatal screening test?
Well, it turns out that I testified earlier that the fetus and the placenta generally have the identical karyotype, and it turns out bits of placental cells get into the maternal circulation, so you can isolate and lyse in the break apart in the maternal circulation, releasing DNA that is essentially similar to the fetal DNA. And you can now remove, through a very complicated procedure, they can collect those scraps of fetal DNA from the maternal blood and analyze that.
And the purpose is to determine the risk that the fetus has certain genetic anomalies, is that correct?
It gives you a risk estimate only for a few anomalies, yes.
And some of those would include the ones you talked about in this study, trisomy 21, trisomy 18, and trisomy 13, is that correct?
Yes.
And what's the purpose of doing those tests?
Well, it's a screening test. We know that as a woman ages, the chances of having a fetus with aneuploidy increases, and now we can determine. The test was originally designed for women 35 and older who could possibly decide to avoid an invasive test by learning their risk of having one of these aneuploidies, because the standard at the time was to do something called an amniocentesis. Then the test got very inexpensive to do, and now it's offered to all pregnant women.
These tests are also called cell-free DNA tests, is that correct?
Right.
Are you able to treat the babies who have a positive result?
Section vague.
Do you understand the question?
I do. We talked about some of the fetal treatments that are available. You cannot correct aneuploidy, but for example, if an aneuploid infant had urethral stenosis with a large bladder, we could theoretically treat that, but you cannot treat aneuploidy or correct it.
So what do parents do with the results if they come back with the aneuploidy result that it's positive for that?
What do the parents do?
Yeah, what do you do with the results? If you can't treat it, what do you do with the results?
Well, I can't, I mean, you're asking me my opinion, what in general parents do, or what, I mean, what I do is counsel them about their options, and then I support their decisions.
And what are those options?
Well, for Down syndrome, trisomy 21, one option would be to do a careful exam of the heart, because if there's no major heart defect, that child has a pretty good chance of surviving and with proper health care leading a long life. And if many parents will elect to continue the pregnancy if that's the case. If there is a very severe heart defect, they might choose otherwise. For trisomy 13 and 18, likewise, we can do an ultrasound to find out what structural abnormalities they have that are associated with those problems. And with that information, the parents can decide whether or not they want to continue the pregnancy or end it.
So one of the options would be to terminate the pregnancy.
Yes.
But these tests can lead to false positives, correct?
Well, we would not terminate a pregnancy based on the screening test you asked me about. That's just a screening test. The patient would have to have a diagnostic test first.
Familiar with the federal agency, the Food and Drug Administration?
Yes?
And they're responsible for, among other things, protecting public health by ensuring safety, efficacy, and security of human drugs, biological products, and medical devices, correct?
Yes?
And the advice and guidance issued by the FDA is relied upon by healthcare practitioners, correct?
Yes?
And in 2022, the FDA issued a warning to patients and healthcare providers about the risks of false positives with these types of tests, correct?
Yes.
I'm going to show you a copy of that warning. If I could have this provided to the witness.
Yeah.
Could you read the very first sentence from this, please?
The U.S. Food and Drug Administration, in parentheses FDA, is warning patients and healthcare providers about the risks of false positive results with genetic non-invasive prenatal screening, or NIPS, tests, sometimes called non-invasive prenatal testing or tests, NIPT. Results from NIPS tests can provide information about the possibility of having a fetus having certain genetic abnormalities that could not result in a child being born with a serious health condition.
If you could go down to the third paragraph and read that paragraph, please.
The FDA is aware of reports that patients and healthcare providers have made critical healthcare decisions based on results from those screening tests alone and without additional confirmatory testing. Specifically, pregnant people have ended pregnancies based only on the results of the NIPS tests. Without confirming the results with a diagnostic test, there's no way to know whether the fetus actually has the genetic abnormality reported on the screening test. The FDA is aware of cases where a screening test reported a genetic...
I'm going to object as hearsay. Move to strike.
The learned treatise exception, Your Honor, calling to attention. A learned treatise, you testified that healthcare practitioners rely on guidance issued by the FDA.
What?
I don't believe this is something that she relied on in her informing her opinion. This is not something that she relied upon in forming her opinion.
All right. I'm going to overrule the objection. I'll allow the information to be submitted. It does seem to be that the testimony was adequate to substantiate the learned treatise exception. All right. Now, I'm not sure how far into the reading the witness was.
I think, Dr. Winstrom, on that third paragraph, you're getting close to the end. If you could just read the very last sentence of that third paragraph, it starts with the FDA.
The FDA is aware of cases where a screening test reported a genetic abnormality and a confirmatory diagnostic test later found that the fetus was healthy.
Treating a pregnant woman, your goal is to do what's best for both the pregnant woman and the unborn child, correct?
Yes.
Physicians treating pregnant women must always consider the health and safety of the fetus, correct?
Yes.
And a physician has an ethical obligation to provide competent medical care with compassion and respect for human dignity and rights, correct?
Yes.
And that includes the right to be free from care that causes harm to the patient, correct?
Yes.
And that would apply to the unborn child as well, correct?
Well, the most important thing that would harm the worst thing that could happen that would harm the fetus is that its lifeline,
Dr.
its
Munson,
mother gets...
It was a yes or no
Okay.
question.
Well, it was... Can you repeat the question?
You testified that under medical ethics and a physician's obligation to provide competent medical care with compassion and respect for human dignity and rights. You testified that that would include the right to be free from care that causes harm to the patient.
That's right.
And that applies to the unborn child as well, correct?
Yes.
Thank you. I don't have any other questions.
All right, thank you, Mr. Craig. Redirect, Mr. Herron.
Yes, sir. Dr. Winstrom, I'd like to follow up on that last question you were asked. What's the most important thing for fetal health?
That its lifeline, the mother, remain healthy. The fetus cannot survive if the mother is damaged or dies.
You were asked several questions about aneuploidy. Could you describe what is aneuploidy?
Well, it's generally considered to mean an abnormal number of chromosomes. But I noticed in that article I was given that some people consider it a rearrangement of chromosomal material.
How does aneuploidy differ from mosaicism?
Well, aneuploidy depends how the test is done, but in general, when you make a diagnosis of aneuploidy, that means that generally every cell in the patient or fetus's body has an abnormal number of chromosomes. But for reasons that would be difficult to explain in this situation, in some fetuses, some cells have a normal number of chromosomes and some are aneuploid. So sometime after the egg is fertilized and the cells start to divide, one population of cells either develops the aneuploidy or corrects itself from the aneuploidy. And that, depending on how large a population of normal cells there are in the body, that can affect the prognosis.
So what's mosaic?
Well, they call it mosaicism because it's like having a black and white tile floor. You know, some of the black tiles would be the aneuploidy, the white tiles would be the normal cells.
How does aneuploidy versus mosaicism affect the chance of fetal survival?
Well, if the fetus has a significant population of normal cells, depending on where they're located in the body, they have a much greater chance of survival than if they don't.
For diagnosis of aneuploid Turner syndrome, what are the chances of survival?
Well, if we could diagnose that accurately, it would be better than for pure Turner syndrome.
You were asked some questions about an article that you wrote. When was that article published?
1995.
So 39 years ago?
Yeah.
Are you confident that the statistics in this article are still accurate today?
Well, to give the benefit of the doubt to those two authors of the two articles that the statistics were derived from, it's possible, but that was an era where those kinds of numbers came from just a small number of patients. You know, not in a randomized trial, not a multi-center trial, and I would have to see what those numbers reflect. For all I know, these reflect the outcomes for the last 79 patients in one hospital. I don't know. But those numbers are not consistent with what we would quote today.
And you were asked, well, before I go there, let me ask you this. You were asked a series of questions about genetic screening tests. Do you remember that?
Yes.
Would you make a diagnosis based on a genetic screening test alone?
No, absolutely not.
What would you do if after a genetic screening test comes back positive?
I would inform the patient of their risk estimate based on the screening test. It's like getting told you have an abnormal pap smear. That doesn't mean you have cancer. It means you could happen. And then if they're interested, I would offer them a diagnostic test, which requires getting a sample of either the placenta or amniotic fluid directly from the fetus and testing that, which would be, more helpful, more accurate.
Would you ever recommend termination based on a genetic screening test alone?
No, and actually, I have given lectures on this topic of why screening tests alone should not be used since 2012 at least. So this FDA document is coming out late, in my opinion.
You were asked some statistics about fetuses surviving to term. Do you remember that?
Yes.
Do the statistics about survival to term include babies who died during childbirth? Do you understand my question?
Well, are you referring in general, or are you referring to those articles?
Well, let's start with in general.
Surviving to term usually means that that they reach at least 37 weeks and they're still alive.
So survival to term, a fetus could survive to term, and the baby could still die during childbirth, correct?
Yes, and that's pretty common.
Can you describe what it looks like when a baby dies during childbirth?
Beyond the scope of cross.
Well, it's...
Hold on just a moment. It's like when a baby dies during childbirth.
What is the experience like for a baby dying during childbirth? He was asking a series of questions about surviving to term, and I'm trying to explain the difference between survival to term is not representative of what actually happens with these lethal fetal conditions. So it's responsive to statistics that are really not the appropriate way to think about the survival rate.
Why don't you rephrase, and then we'll see if if a new question draws the same or different objection. I feel like it was hard to understand what the question was getting at.
Sure. When you're counseling patients who receive a lethal fetal diagnosis, do you counsel them about the chances of survival to term as well as what could happen during childbirth?
Yes.
What could happen during childbirth?
Objection beyond the scope of cross, and it's not relevant.
If you're inquiring, if the question about what could happen during childbirth deals with the prospects of fetal survival, maternal health implications, if that's what the question is designed to get at, I'll permit an answer as to those topics. If it's getting at something else, then no. So,
that's exactly what I'm getting at, Your Honor.
go ahead.
So if a fetus has a lethal diagnosis and does survive to term, it's highly likely to die during labor. I think I kind of touched on this earlier. That requires a long, usually painful discussion with the patient about how we're going to handle labor, knowing that the fetus is likely not to survive it. Are we just not going to monitor? Are we going to monitor, et cetera? For the patient, it's physically, it's undergoing all the stress of action.
Yeah, this goes beyond what the court said the court would allow.
Let's have a new question.
Your Honor, I may briefly respond. Several of the questions had to do with maternal health and also fetal health, and the experiences, and those were questions asked during the cross-examination. Many of these experiences do get to that. It's well within the scope.
Understood. I guess I'm not directing you to move on. I'm just, if you would ask another question that's designed to elicit the information you're seeking.
So when there is childbirth of a fetus with a lethal fetal condition, how does that affect the pregnant patient, the patient who's giving birth, their physical health?
Well,
Overruled. You can answer.
Well, labor delivery is traumatic. a lot of things can happen during that labor. It's painful. They could have bleeding problems. They could develop problems with their blood pressure. In a normal pregnancy, there's always the issue of how the fetus is tolerating labor, and we make recommendations based on that. But if the fetus has a lethal condition, then we have to figure out how the patient is going to deal with that. Do they want the fetus to die before its birth, or can they accept that? And what are we going to do if not? Are they going to have a section so that the lethal condition, they can at least say goodbye to their fetus? And if they do that, then they accept all the risks of a surgery for a child that won't survive. So those are all the physical stresses, but it's incredibly emotionally devastating.
That was going to be my next question. Can you describe the mental impact?
So,
Beyond scope across, and I think it's beyond the scope what the court said the court would permit. It's also leading.
I'm going to sustain the objection at this point.
well, okay,
I have a new question.
sorry.
Can you describe what happens with a baby who is born with a lethal fetal condition?
I'm sorry.
What happens with a baby who is born who has a lethal fetal condition?
Object beyond scope across.
So you're asking after the delivery?
Object beyond scope across.
Sorry.
All right. You can go ahead and answer if you understand the question.
It's after delivery and during delivery.
Well, in every hospital I've worked in, we create memories for the patient. We do fetal footprints. We clean the fetus off, wrap it up, take pictures, have the patient hold it. It's kept in the room. We try.
All right.
That's not- yeah.
That's not your question?
I don't think that that's what he was getting at, but I certainly don't blame you for not trying.
Okay.
Let me rephrase the question. From a health standpoint, from a physical condition of a baby born with a lethal fetal condition, can you describe what happens physically with the baby?
I'm sorry. I answered as if it was assumed that the fetus would not survive delivery. It dies.
Hold on just
I'm sorry. I'm having trouble feeling all the objections, so I
Understood.
sincerely
And
apologize.
so when there's an objection made, it's appropriate for you to pause and wait for me to make a ruling, and then if the objection is overruled, to answer.
I'm sorry. I just can't hear him, so I'll keep an eye on his face. So,
I'll try to speak up. So I'll
All right.
again object beyond the scope across.
okay.
All right. Understood.
I'm very sorry.
No apology necessary at all. All right. I'm going to sustain the objection at this point.
Your Honor, may make an offer of proof.
Go ahead.
Dr. Winstrom, can you describe physically what happens with a baby born with a lethal fetal condition? What do those babies look like? What happens in the process while the baby is dying?
Same objections. I just ask that we find out where we're ending the offer of proof and where we're not.
All right. Understood. You can answer the question.
Generally, a pediatrician is asked to attend the delivery and evaluate the fetus, the baby then, who's been born. If the diagnosis is indeed correct and the patient has requested this, they'll provide comfort care while the baby expires in most situations.
You testified that cases of gestational diabetes can be treated during pregnancy. Are there cases, or that I believe that was in the deposition transcript that you read, are there cases of gestational diabetes that cannot effectively be treated during pregnancy?
Well, gestational diabetes is diabetes diagnosed for the first time during pregnancy, and some of those women actually probably have pre-gestational diabetes. So they aren't managed just with a diet. They often require insulin. And if that's the case, then they can develop serious pregnancy complications.
I believe you read a portion of your deposition transcript that stated that there are not that many conditions where whatever is wrong with the mother requires ending the pregnancy. Do you recall that?
Yes.
Are we still on the offer of proof, or have we?
I don't think so. I think it was one question and one answer, and that's it. That's as I understood it.
Okay.
All right.
Were you referring to the number of conditions or the rarity of the conditions? What did you mean by that?
I was referring to conditions that the average practitioner is likely to see on a regular basis. As a geneticist, I have to acknowledge that there are other rare conditions that also would apply, but the average person wouldn't see in their professional life.
Can you create a set list of conditions where the condition requires ending the pregnancy?
May I ask fetal conditions or maternal conditions?
Either one.
No.
How do you evaluate each individual patient?
Based on their history, their physical exam, their presenting symptoms, any test results we have, including ultrasounds and genetic tests if relevant, and then come up, that's how we make our assessment.
Nothing further, Your Honor.
All right, thank you. Anything else for this witness, Mr. Craig?
No, Your Honor, nothing further.
Thank you for being here, Dr. Wenstrom. You may step down. Plaintiffs may call their next witness.
Your Honor, Hannah Dunham for the plaintiffs. We call Dr. Ali Raja.
Good morning, Dr. Raja.
Good morning, Your Honor.
Take a seat.
Thank you, Your Honor.
Good morning, Dr. Raja. Can you please state your name for the record?
Yes, ma'am. It's Ali, A-L-I, Shabazz, S-H-A-H-B-A-Z, Raja, R-A-J-A.
And where do you live?
I live in Boston, Massachusetts.
And what's your profession?
I'm an emergency physician.
Dr. Raja, you have in front of you a binder. Would you look at Plaintiff's Exhibit 14?
Yes, ma'am.
And what is that?
It is my CV, my curriculum vitae.
And is this CV an accurate representation of your training and professional activities?
Yes, ma'am, it is.
And is it up to date?
No, ma'am, there's been some minor changes over the past year. This one's dated January 1st, but nothing substantial.
Okay, so it was up to date as of January 1st, 2024?
Yes, ma'am.
Plaintiffs move for admission of Plaintiff's Exhibit 14.
Just for the purpose of demonstrating the witness's qualifications, is that right?
Correct.
Any objection?
No, Your Honor.
All right, Exhibit 14 is admitted.
Dr. Raja, where did you go to medical school?
I went to med school down at Duke in North Carolina.
And did you pursue any additional education?
Yes, ma'am.
What was that?
After that, after I graduated from medical school, at the same time I went to business school and got an MBA. And then after that, I moved to Ohio, where I was a resident in emergency medicine at the University of Cincinnati.
And how long was your residency?
It was 4 years.
What did you do after your residency?
After residency, I moved up to Boston, where I did a research fellowship at Brigham and Women's Hospital and Harvard Medical School. I'm sorry. I will definitely slow down. Sorry about that. I moved up to Boston, And I did a research fellowship at Brigham and Women's Hospital and Harvard Medical School, and I've stuck around there ever since.
Do you have any other postgraduate education?
Yes, ma'am. I went to the School of Public Health at Harvard and got an MPH, and then went to business school again for some reason out at Case Western and got a doctorate there.
And you testified that you are an emergency physician. Are you board certified in emergency medicine?
Yes, ma'am, I am.
And who are you certified by?
I'm certified by the American Board of Emergency Medicine,
Where are you currently licensed to practice?
just in the state of Massachusetts.
Have you ever been licensed to practice in other states?
I have, yes. Many years ago, I was moonlighting as a locums tenens physician, and there were a number of other states. I can't remember them all, but they were Washington State, I was out in Michigan, and a few more.
And how long have you practiced medicine?
I've been practicing since 2008 when I finished residency.
So about 16 years?
Yes, ma'am, that's right.
Where are you currently employed?
Currently, I am employed at the Massachusetts General Physicians Organization. It's the group that staffs the Massachusetts General Hospital.
And do you mind if I call that Mass General?
No, ma'am, not at all.
Oh, what is your role at Mass Gen?
I'm the deputy chair for the Department of Emergency Medicine, so I'm responsible for all of the clinical operations in the department as well as the quality improvement programs and the research and the education that we do.
Do you treat patients in your role as deputy chair?
Yes, ma'am, I do.
And do you treat any pregnant patients in your role as an emergency medicine physician at Mass General?
Yes, ma'am, I do.
Do you promulgate any procedures or protocols for use in Mass General's emergency department?
Yes, ma'am. As the one in charge of the clinical operations of the department, I work with my colleagues to write policies and procedures, and then we use them in the department.
Do you teach anywhere?
Yes, ma'am. I'm a professor at Harvard Medical School.
And what do you teach at Harvard Medical School?
I'm a professor of emergency medicine, so I teach emergency medicine to medical students and residents and lots of other folks.
Do you train any residents who focus in other specialties?
Yes, ma'am, I do. As part of their residency training, residents from other specialties will come down to the emergency department and they'll learn from us.
And do you train students or supervise residents in the treatment of pregnant patients who present to emergency departments?
Yes, ma'am, I sure do.
Where do your residents go to practice emergency medicine after you've trained them?
They go all over the country. We've got folks who work all over the country, and I guess we've got folks who have gone internationally as well.
Do you practice in any medical conferences or societies? Do you participate in any medical conferences or societies?
Yes, ma'am, I sure do.
Which ones?
I'm a member of the American College of Emergency Physicians, where I've held a number of leadership roles, and I'm currently the president of the Society for Academic Emergency Medicine.
And what is the Society for Academic Emergency Medicine?
It's about 9,000 emergency physicians around the country who work primarily at academic teaching hospitals, where we teach residents, teach medical students, and so focus on the academic part of our specialty.
Are there members of the Society for Academic Emergency Medicine from Idaho?
Yes, ma'am, there are.
And do you interact with physicians in Idaho in your role at the Society for Academic Emergency Medicine?
Yes, ma'am, I do.
Before we move on, did you work with counsel to prepare a slide deck to assist with your testimony?
Yes, ma'am, I sure did.
And did you provide the content for those slides?
Yes, ma'am.
Why did you prepare that slide deck?
Mostly as a reminder to myself to make sure that I covered the points that I wanted to cover, but also because I thought there would be some helpful aids in my presentation.
And how many slides did you make?
7.
We discussed earlier that you were an emergency medicine physician. On what were you asked to render an opinion in this case?
I was asked to render an opinion as to how the Idaho laws pertaining to abortion could be interpreted by emergency physicians.
Dr. Raja, please look at slide 1 in your binder behind the demonstrative tab. What does this slide show?
Objection, hearsay.
I'm just asking him to describe generally what's on the slide, not the content of the slide.
All right, overruled. You can answer.
Thank you, Your Honor. It shows a summary of the opinions that I have in the case.
Your Honor, I asked to publish slide 1 to assist in Dr. Raj's testimony.
I'll object for hearsay until he testifies about it. It would be hearsay, and so he.
All right. Well, you're not. It's not being proposed for admission into evidence. Is that right? It's a testimonial aid. I'm inclined to allow it. You may proceed.
Thank you, Your Honor.
We'll dive deeper into these opinions in a moment, but for now, would you just share an overview of your opinions with the court, please?
Yes, ma'am. Overall, there are 2, but the first one has 4 parts. The first is that the Idaho abortion bans will prevent physicians from offering timely life or health-preserving abortion care for pregnant patients with emergent conditions because of the 4 following reasons. First, that the total abortion ban's medical exception is unclear and confusing. Second, that the 6-week abortion ban's medical exception is unclear and confusing. Third, that abortion bans, the 2 of them, contain conflicting language. And finally, as part of Opinion 1, the abortion bans contain harsh penalties that could have a chilling effect on physicians' willingness to care for patients.
And what is your second opinion?
My second opinion is that the abortion bans here in Idaho harm both patients and physicians by preventing physicians from practicing under the national medical standards of care.
And what is the basis for your opinions today?
It's based on the training I've received, my experience over the years, as well as all of the articles that I've read and written over time.
What materials did you review for purposes of providing your opinion?
I reviewed the total abortion bans themselves. I reviewed the portions of the Planned Parenthood decision. I also discussed their personal experiences with Drs. Corrigan and Lyons.
Did you review any medical literature in connection with reaching your opinions?
I did not, no.
Did you review anything else in connection with reaching your opinions?
I did. I think that one of the slides is a slide that I pulled from the Kaiser Family Foundation's webpage, just to understand the state of healthcare in Ohio.
Was there anything else you wanted to review?
Idaho.
Oh, sorry. Was there anything else you wanted to review?
Still stuck on my residency. No, ma'am.
Dr. Raja, what do emergency medicine physicians do?
Our job as emergency medicine physicians is to evaluate patients when they come into the emergency department and to decide, based on their history, based on the exam that we perform, based on any testing that we do, what treatment they need. And it's to decide that quickly and often with limited medical information.
And how do emergency medicine physicians examine patients when they first present to the emergency department?
It depends a lot on what they present with. The exam for a patient who comes in with a sprained ankle is going to be different for the exam for a patient who comes in with a gunshot wound to the chest. But based on their presentation, we'll focus our exam on the body part or the area that seems to be most injured and go from there.
And what if that patient is pregnant? Is your examination process any different?
It can be, ma'am. If the patient comes in with an illness that might be a result of the pregnancy or might complicate the pregnancy, it might differ. But for some patients, if a pregnant patient comes in, for example, with a sprained ankle or a potentially broken ankle, that exam would probably be pretty similar.
Are you able to determine whether a pregnant patient is experiencing an emergent condition related to pregnancy that requires medical care?
Yes, ma'am. I'm sorry.
Sure. Are you able to determine whether a pregnant patient is experiencing an emergent condition related to pregnancy that requires medical care?
Yes, ma'am, I am.
And if you determine that a pregnant patient has an emergent condition related to pregnancy, what would you do next?
It would depend a lot on what that emergent condition was, ma'am. I'd first make that diagnosis. And if that diagnosis was related to pregnancy, I'd discuss with the patient the fact that I needed to consult an OBGYN. And then I'd call that OBGYN, and she or he and I would together continue to care for the patient.
Are there any situations where you would determine that the pregnant patient has an emergent condition related to pregnancy and may need an abortion?
Yes, ma'am.
If you determined that a patient needed an abortion, would you also call a specialist?
I would. Yes, ma'am. And to be clear, I would determine that abortion was one of the options. But as the OBGYNs are the ones who actually perform the abortion, I would discuss the fact that an abortion was an option with the patient and then pull in an OBGYN to continue their care.
Are there any situations in which you determined that one of the courses of care is an abortion, but you wouldn't call a specialist?
Well, ma'am, if I was in a situation where I felt legally I couldn't call a specialist, then yes.
And what would you do in that situation?
In that situation, I would be.
Vague.
Overruled, you can answer.
In that situation, ma'am, I'd discuss with the patient the fact that while medically the standard of care would be for an abortion to be one of the options for their care, that in their particular situation, I wasn't able to call a consultant.
And would you do anything with the patient after you'd provided that consultation?
It would be on a pretty individual basis, ma'am. I'd try to give all the care that I felt that legally I could.
And you mentioned you were certified by the American Board of Emergency Medicine. What is that?
The American Board of Emergency Medicine is the regulatory board that gives us a test after we finish residency and determines whether or not, based on how we do on that test, there's 2 steps, whether or not we can become board certified to practice emergency medicine.
In preparing your opinions in this case, did you review any American Board of Emergency Medicine guidance?
Yes, ma'am, I did.
And what did you review?
I reviewed what the American Board of Emergency Medicine calls the core, the model of clinical practice. And I apologize, I didn't remember exactly what it was called, but it's the model of clinical practice that essentially outlines what we as emergency physicians do.
Dr. Raja, would you please turn to Plaintiff's Exhibit 211 in your binder?
Yes, ma'am.
What is that?
That's the latest version of the model of clinical practice. It's the 2022 version. It'll be revamped again in 25.
And do you rely on this model of clinical practice as deputy chair of Mass General's Emergency Medicine Department?
Yes, ma'am. This is how we train our residents. This is what we train them on. And this is the board exam that we train them for.
Now, please look at slide 2 under the demonstrative tab. What does this slide show?
Ma'am, this slide shows table 2 from that document, which essentially defines the different acuities or the seriousnesses, that's not even a word, I'm sorry, the various acuities that patients can present with to the emergency department.
Your Honor, I asked to publish slide 2 to assist with Dr. Raja's testimony.
Go ahead.
Dr. Raja, what are these 3 patient acuity categories?
In general, when patients come to the emergency department, they can be critically ill, they can be emergently ill, or they can have a lower acuity illness.
So I'd like to focus on that emergent category. How does the ABEM define an emergent condition?
Ma'am, the American Board of Emergency Medicine defines an emergent condition as patients presenting with symptoms of an illness or injury that may progress in severity or result in complications with a high probability of morbidity if treatment is not begun quickly.
And how is that different from the first category, the critical category?
Yes, ma'am. In general, patients who come in critically ill need something done right now. They need some immediate intervention. Think of the patient who can't breathe and needs an intubation or a breathing tube put down, or somebody who is losing a lot of blood from a gunshot wound and needs that bleeding stopped, something that needs to be done in the next few minutes. An emergent patient, which is the highlighted category here, they are likely to progress in severity and have complications that may result in them dying or at the very least becoming much more sick if treatment is not begun quickly, but it doesn't need to happen in the next few seconds.
And do these categories apply to patients who present to the emergency room who are pregnant?
Yes, ma'am, they do.
All right, turning back to 211, would you please turn to pages 35 and 36?
Yes, ma'am.
And what does this show?
This shows a section of the model of clinical practices that focuses on obstetrics and gynecology.
And please look at slide 3 under the demonstrative in your binder. What does this slide show?
Yes, ma'am. This was a slide that I pulled together to highlight the relevant portions of those 2 pages.
Your Honor, I asked to publish slide 3 to assist with Dr. Raj's testimony.
Your Honor, I'm going to object as hearsay, and you're allowed to read learned treatises into the record. I don't think you're allowed to publish them and show them and such, so I'll object.
I think this might be something that would be handled differently if we were in front of a jury, but I don't see a reason to impede this mode of presentation, so I'll permit that.
Dr. Raj, are these the same conditions that are on pages 35 and 36 of Exhibit 211?
Yes, ma'am. There are some of them.
And are there complications of pregnancy that the American Board of Emergency Medicine has put into the emergent category?
Yes, ma'am. There are.
And what are some examples of those conditions?
Some examples are patients who come in with hemorrhage, with hyperemesis gravidarum, with gestational hypertension, with infections, and there are others there as well.
Do these conditions pose a risk to a pregnant patient's future fertility?
Yes, ma'am, they can.
And what are some conditions that could lead to a loss of future fertility?
Infections, ma'am, for example, and that covers a wide spectrum of infections. But in a patient who comes in with a premature pre-viable rupture of membranes, that can lead to an infection called chorioamnionitis, which can lead to a hysterectomy if not treated.
You can set that aside.
Yes, ma'am.
Dr. Raja, what does standard of care mean in the medical context?
In the medical context, ma'am, it's what a physician would do under the circumstances for which they've trained. In emergency medicine, it is that we see and evaluate patients quickly, and that we give them evidence-based medical treatment based on the best medical judgment that we have.
And is the standard of care specific to any state?
No, ma'am, it's not.
What makes the standard of care for emergency medicine national?
A couple of things, ma'am. First is that we train all of our residents around the country using this model of clinical practice. And it's the same, no matter whether you're training in Idaho, Chicago, Florida, or Massachusetts. Secondly, after all that training is done, all emergency physicians around the country take the same board exam. Unlike attorneys, for example, there are not state-specific board exams. An emergency physician who is board certified in Idaho takes the exact same board certification exam that I took in Massachusetts.
Do board exams cover state law?
No, ma'am, they do not.
And who administers the board exam for emergency medicine?
It's the American Board of Emergency Medicine.
Do you know who sits on the board of the American Board for Emergency Medicine?
Yes, ma'am. They're members of ABEM who have been elected by other members of ABEM.
Should all emergency medicine physicians adhere to the same national standard of care that you just described?
Objection, leading.
Well, I wouldn't say that that's leading. Potentially objectionable on other grounds, but I'll overrule that objection.
Yes, ma'am. We should.
And does the national standard of care for emergency medicine use common language that all emergency physicians can understand?
Yes, ma'am, it does. It uses, oh, I'm sorry, I couldn't hear you. That's the only reason I kept going.
No problem. Thank you. So will you restate the question, please?
Sure. Does the national standard of care for emergency medicine use common language that all emergency physicians can understand?
All right. So the objection to that was hearsay. I don't believe the question calls for hearsay. I'll overrule that objection. You may answer.
Yes, ma'am, it does. It uses language that I commonly use when I'm training my residents.
And to your knowledge, do all emergency medicine physicians learn the same vocabulary to understand various emergent conditions and appropriate medical responses?
Yes, ma'am.
And given your extensive experience and training, do you understand the common vocabulary taught to emergency medicine physicians?
Yes, ma'am, I do.
And likewise, would you be able to identify language that is not typically taught or understood by emergency medicine physicians?
Yes, ma'am, I would.
So you testified that all emergency physicians across the country should follow the national standard of care. Does that mean that physicians can be trained in one state but practice in another?
Yes, ma'am, it happens pretty frequently, actually.
And how would a physician do that?
Emergency medicine is one of those specialties where we don't have our own patients. There aren't, unlike a family practitioner or a pediatrician, there aren't patients who come see me all the time. And basically, I just need an emergency department to work within. And that can happen anywhere in the country. And so emergency physicians will commonly work in multiple different states over the course of a year, often traveling in and then traveling back home. And those physicians are called locums tenens physicians.
And in order to practice in another state, what does that physician have to do?
Two things, ma'am. First, they have to get a medical license in that state. And then second, within that state, they have to find a clinic or a hospital that will credential them to practice emergency medicine there.
Are there any state-specific tests that Idaho requires before allowing an emergency physician to practice in that state?
No, ma'am, there are not.
Object to lack of personal knowledge outside his level of expertise. He's not been disclosed as an expert to testify on Idaho standards for practicing emergency medicine.
Well, I couldn't say what the disclosure was and whether it consisted of opinions from Dr. Raja as to what the requirements are to be licensed to practice in Idaho. Was there a disclosure on that point?
Your Honor, Dr. Raja's opinions were that there is a national standard of care. There is no requirement for each state to have a separate standard of care or a separate training. So this is just getting at that point.
All right, and so this question was, I guess, beyond whether or different than whether there was some particular standard of care that operates in Idaho. It seems to me that the particular question was outside the scope of what you just said you disclosed. So I'll sustain that objection. I'll disregard that one answer. You may continue.
Does the national training you provide to medical students and residents include state law requirements?
No, ma'am, it does not.
And does that national training include how to interpret state laws?
It does not. No, ma'am.
Are physicians always able to provide care in accordance with the national standard of care?
Not always. No, ma'am.
And why not?
Typically, that's because of the fact that different hospitals have different capabilities. A large tertiary referral center, meaning a hospital that other hospitals send their patients to here in Boise, might have capabilities that other hospitals outside of Boise just don't have. And so an emergency physician working at a smaller hospital would know what the standard of care was, but might not be able to give it. For example, cardiac catheterizations are treatments for heart attacks, but they're few and far between. And so sometimes a smaller hospital will have a patient with a heart attack, know that they need a cardiac catheterization, and then have to send them elsewhere to get that.
Are there situations where a state law constrains a physician's ability to provide services in accordance with the national standard of care?
Yes, ma'am.
And how would state law do so?
It might do so, ma'am, in the ways that we're discussing here today around restricting which patients may or may not be eligible for standard of care treatments.
Would a state law be able to...
Object. I think that misstates the law and calls for a legal conclusion.
So in saying misstating the law, are you saying that this, I think what you might be saying is that the statutes at issue, rather than restricting patient eligibility, what they do is criminalize the provision of the care. Is that the misstatement, or is it something else?
He was misstating what Idaho law says. That is correct.
In the way I suggested it was a mistake.
Among others, yes.
All right. So perhaps you can. I'll not consider the last answer. If you want to get at the topic again through another question, go ahead.
We'll get back to that topic. Would a state law be able to change the national standard of care?
No, ma'am. A state law can't change the national standard of care.
Is abortion care ever the appropriate standard of care for emergent medical conditions that pregnant patients experience under the national standard of care? Is abortion care ever the appropriate standard of care for emergent medical conditions that pregnant patients experience under the national standard of care?
Yes, ma'am. It can be.
And how do you know that?
Through my experience and my training.
I'd like to turn now to your opinions. Dr. Raja, are you familiar with Idaho's abortion bans?
Yes, ma'am, I am.
And how many abortion bans does Idaho have?
2, ma'am.
Dr. Raja, please look at slide 4 in your binder. What does this slide show?
This slide shows excerpts from both the total ban as well as the 6-week ban. Ma'am.
Your Honor, I asked to publish slide 4 to assist with the testimony.
Go ahead.
Dr. Raja, what is your understanding of the total abortion ban?
That it limits the performance of abortions with the exception of a medical exception that I've outlined on a different slide.
And what is your understanding of the 6-week abortion ban?
Similarly, that it restricts the performance of abortions after the presence of a heartbeat, about 6 weeks or so, and with a medical exception that, again, is on the next slide.
And please turn to that slide. What does that show?
This shows excerpts of the medical exceptions for both pieces of legislation, ma'am.
And Your Honor, I asked to publish this as well.
Go ahead.
Dr. Raja, what is the medical exception for the total abortion ban?
It's when a physician determines in his good faith medical judgment and based on the facts known to the physician at the time that the abortion was necessary to prevent the death of the pregnant woman.
And then what about the 6-week ban? What's the medical exception?
It defines the exception as a medical emergency, meaning that a condition that, in reasonable medical judgment, so complicates the medical condition of a pregnant woman as to necessitate the immediate abortion of her pregnancy to avert her death, or for which a delay will create serious risk of substantial and irreversible impairment of a major bodily function.
Dr. Raja, looking at the medical exception language for the total abortion ban, is there a language there that is unclear and confusing for emergency physicians?
Yes, ma'am, there is.
And what is that language?
Specifically, determining that an abortion was necessary to prevent the death of the pregnant woman.
And why is this language unclear and confusing to emergency physicians?
Because it's impossible to predict, ma'am, whether or not an abortion was necessary to prevent the death of a pregnant woman, or whether that patient would have gotten more sick, spontaneously miscarried, or potentially died as a result of the illness that was being treated with the abortion.
Is this language that physicians are trained in or that they commonly use?
No, ma'am, it's not.
Dr. Raja, you testified that you reviewed portions of the Planned Parenthood case. Is that right?
Yes, ma'am, I did.
Has the Idaho Supreme Court already addressed this language in their opinion in the Planned Parenthood case?
They addressed the temporal nature of it. There was some discussion about the immediacy of the prevention of the death, but I don't know that more details were given.
And given that opinion, do you still consider this language to be unclear and confusing to emergency physicians?
Yes, ma'am, I do.
And why?
For the same reason. It's simply that the prevention of death of a pregnant woman, it's just impossible for us to know if treating or not treating will lead to death or simply worsening of illness, loss of fertility, or a number of other complications that are not as severe as death, but also possible.
Can you give me an example of a situation where it would be difficult for an emergency physician to apply this medical exception?
Yes, ma'am. PPROM comes to mind.
And can you explain why it would be difficult for an emergency physician to treat a patient presenting with PPROM?
Yes, ma'am. With that previable, preterm rupture of membranes, patients are at high risk of infection. But that Sorry, I thought I heard an objection, but I didn't. But that risk of death is on a spectrum. If they develop an infection, that infection may be treatable or it may not. It may be that that infection turns into sepsis and turns into a loss of kidney function or heart function or lung function, or it may lead to death. That predictive ability is just something that we don't have in emergency medicine or medicine in general, which is why we're always taught to treat patients as early as possible to prevent any morbidity or, in this case, death.
Is abortion the national standard of care for PPROM?
Ma'am, people use the acronym in different ways. It is the national standard of care as an option for pre-viable PPROM.
And even though abortion care is one of the options for the national standard of care for pre-viable PROM, is that fair to say, how I describe PPROM?
Yes, ma'am.
Okay. So even though abortion care is one of the options under the national standard of care for pre-viable PROM, in your experience, is it clearly allowed under the total abortion ban's medical exception?
No, ma'am, it is not.
Is there any...
To object, lack of personal knowledge, he has no experience treating patients in Idaho.
I think she meant to say something different than in your experience. I think she may have meant to say in your opinion, perhaps, but perhaps you can rephrase the question.
Thank you, Your Honor. So, Dr. Raja, even though abortion care is one of the options under the national standard of care for pre-viable PROM, in your opinion, is it clearly allowed under the total abortion ban's medical exception?
No, ma'am, it is not.
Is there any medical benefit to delaying abortion care in that case?
No, ma'am, there isn't.
It's for speculation.
Overruled. Answer stands.
Are there other emergent circumstances where the medical consensus is that abortion care is the appropriate treatment according to the national standard of care?
Yes, ma'am, there are.
Assuming a doctor decides not to provide abortion care when a patient presents with pre-viable PROM or another circumstance where abortion is the appropriate treatment and discharges the patient home, are there risks to that patient?
Yes, ma'am.
And would those risks apply to patients who are denied necessary abortion care and sent home in Idaho?
Yes, ma'am, they would.
And is there any greater risk to a patient who is sent home in Idaho after being denied necessary abortion care compared to patients in other places across the country?
Objection, vague, calls for speculation. He's not ever practiced in Idaho.
Overruled. You can answer.
Yes, ma'am, there are.
And why is that?
Because of the fact that Idaho has, amongst the 50 states, one of the lowest numbers of hospital beds per capita across the state. And so were a patient to be sent home instead of receiving an abortion that would be one of the options as per the national standard of care, and they got sicker, they would have a harder time finding a hospital bed, and getting treatment.
Dr. Raja, please look at slide 6 in your binder. What does this slide show?
Ma'am, this shows an image from the Kaiser Family Foundation's webpage.
And Your Honor, I asked to publish this to assist with Dr. Raja's testimony.
Go ahead.
I'll object for hearsay. Again, you can have learned treatises read into the record, but to display a slide, I'll object.
Okay. Well, the audience for the slide, I guess, is really me, and I'm the same person that would have to look at whatever is in a learned treatise to determine whether it ought to be allowed to be read into evidence. So I don't see the harm. You may proceed.
Dr. Raja, remind us, who developed this study?
This was a study done by the Kaiser Family Foundation. They're a nonprofit medical think tank.
And did you rely upon this information in forming your opinions?
I did, yes, ma'am.
And according to this study, where does Idaho rank out of the 50 states in terms of hospital beds for 1,000 people?
Unfortunately, ma'am, it ranks 46th out of 50.
And how many hospital beds does Idaho typically have for 1,000 people?
It has 1.85 beds per 1,000 people.
And how does Idaho's number of hospital beds impact the risk to patients when they are sent home without the treatment that they need?
Objection asked and answered, calls for speculation.
It was asked and answered. I'll sustain that objection.
I can move on. You can set that aside. So, Dr. Raja, I want to turn back to slide 5, which shows the medical exceptions, and I want to focus on the 6-week ban's exceptions. In your opinion, is there language in the 6-week abortion ban medical exception that is unclear and confusing for emergency physicians?
Yes, ma'am.
And what is that language that is unclear and confusing?
There's a number of things, ma'am. The first is the concept of reasonable medical judgment. Then secondly, the verbiage around the necessity of an immediate abortion to avert her death, and also the terminology around the fact that a delay would create a serious risk of substantial and irreversible impairment of a major bodily function.
I want to take those in turn, starting with reasonable medical judgment. What makes that language unclear and confusing for emergency physicians?
Just that, ma'am, I didn't know what it meant. It's not something that we use regularly. I understand that it's a legal term, but from my understanding, it's not a term that I've ever used with any of my residents when I train them.
And what about immediate abortion of her pregnancy to avert her death? What about that is unclear and confusing?
The difficulty there, ma'am, is the qualification of the word immediate. Often abortions happen quickly, but they can also happen over time, sometimes even days. And especially if a physician is considering transporting a woman to a center that's able to do an abortion that they might not be able to do at their hospital, that abortion obviously won't happen immediately. And so that language is unclear and hard to understand.
Then I think the last thing you highlighted was serious risk, substantial and irreversible impairment of a major bodily function. What about that language is unclear and confusing?
Yes, ma'am. The concept of a serious risk is just simply not defined. I'm not sure what a serious risk is, and emergency physicians wouldn't be able to classify some risks as serious or not serious in a way that we just don't normally use those terms. Similarly, knowing what a substantial versus an insubstantial risk is something that I wouldn't be able to define. And similarly, an irreversible impairment is also one that we can't predict. Some impairments can improve, some impairments might not improve, and being able to proactively decide, especially in an emergency department when patients need to be treated quickly, what is and is not irreversible over time is just impossible.
Do you train residents on the language serious risk?
No, ma'am.
Do you train residents on the language substantial and irreversible impairment?
No, ma'am.
Do you train residents on the language major bodily function?
No, ma'am. Thank you. I hadn't actually gotten to that, but no, we don't train them on what is major and, I guess, minor bodily function.
You also testified that one of your opinions in this case is that the abortion bans contain conflicting language. What about the language in these two medical exceptions conflicts?
Objection, calls for a legal conclusion.
But to consider the answer as Dr. Raj's perception and not as an authoritative legal interpretation of the statutes. With that qualification, you can answer.
Thank you, Your Honor. There's a few things, ma'am. The first is the pieces around medical judgment and the difference between good faith and reasonable. And then also the necessity of mortality prevention in the total ban, prevent the death, versus the broader, but also, as I mentioned, vague definition around death or a major bodily function impairment in the 6-week ban.
You mentioned the medical judgment standards. What is your understanding of what reasonable medical judgment means?
From what I understand, ma'am, it's a retrospective evaluation based on what someone else, whether it's a prosecutor or another physician, decides was reasonable for that physician at that time.
And what is your understanding of what good faith medical judgment means?
That it's based on what that physician intended to do prospectively with their treatment for that patient.
Are either of these standards language that physicians are trained in or that they commonly use?
Neither one are standards that we're trained in. Neither ones are standards that we commonly use, although good faith seems to be similar to what I generally teach my residents.
In your opinion, would physicians be able to have a consistent understanding of the language in both of these exceptions?
No, ma'am, they would not.
Would the conflicting standards in these exceptions cause physicians to delay treating pregnant patients with emergent medical conditions?
Yes, ma'am, they could.
What is your understanding of what the consequences of incorrectly interpreting the standards would be?
Objection, speculation.
So I'm not sure if you're talking about medical consequences or legal consequences at this point.
I'll clarify. What is your understanding of what the legal consequences to an emergency physician would be of incorrectly interpreting these standards?
Objection calls for speculation outside his expertise.
Your Honor, he's reviewed the laws. He's aware of what they say.
Well, is he going to testify that a physician could, I guess, make a decision on what care to render, thinking they're complying with the law, and then finding out later in court that they weren't, and therefore they wind up in prison? Is that where this leads, or does it lead somewhere else?
You know, one of his opinions is that the harsh penalties in these laws chill the provision of care. So I'm just trying to lay the foundation that he understands what the penalties are for violating these laws.
All right. So the question is just designed to get at his understanding what the potential penalties are, and then you go from there. All right. So on that understanding, I'll permit the line of questioning to continue. So perhaps you want to restate your question.
Dr. Raja, what is your understanding of what the legal consequences would be to an emergency medicine physician of incorrectly interpreting these standards?
My understanding, ma'am, is that there are civil and potentially criminal penalties, as well as loss of licensure and imprisonment.
And how do these legal consequences impact emergency physicians' ability to provide timely care to pregnant patients?
Objection calls for speculation.
So I guess I'm kind of quibbling with the verbiage of the question. I think if the question were how might these legal consequences impact emergency physicians' ability to provide timely care to pregnant patients, then the objection would be resolved. It would not be objectionable as such. So I'll ask you to answer that question.
Thank you, Your Honor. They might result in emergency physicians delaying or even denying care.
And does the national training you provide include withholding treatment until it is necessary to prevent the death of the patient?
No, ma'am, it does not. It involves treating patients as early as possible to prevent them from getting more sick or dying.
And does the national training you provide include withholding treatment until it is immediately necessary?
No, ma'am, it does not.
Dr. Raja, please look at slide 7 in your binder. Generally, what does this slide show?
This shows the 3 choices that I feel emergency physicians face when treating patients in Idaho.
Your Honor, I asked to publish this slide.
Go ahead.
Dr. Raja, what are those options?
First, to deny treatment, which obviously harms patients by refusing to provide care consistent with the national medical standard of care. The second is to delay treatment, regardless of the pregnant patient's immediate needs, until the patient's health further deteriorates. Or third, to provide care, but at risk of onerous criminal, civil, and licensure penalties that may threaten the physician's freedom, livelihood, and career.
And what are the risks to patients of doctors denying or delaying treatment?
Significant, ma'am. They could worsen in their illness, or they might die.
Thank you. No further questions. I pass the witness.
All right. Thank you, Ms. Dunham. We're at about 12:05. I thought I'd inquire about if you can ballpark the length of your cross-examination, perhaps you can, and I don't want to limit it, but if we're talking potentially 20, 25 minutes, perhaps we could finish up. If you think it might go longer than that, perhaps we'll take the lunch break instead.
I'd suggest take the lunch break. I can't promise how long it's going to take, so let's just take the lunch break.
All right,
Okay.
understood. Well, sorry to detain you for a while longer, Dr. Raja. We'll plan to take our recess now. Let's reconvene at 1:15. We'll be in recess.
Session.
Please be seated. All right, Mr. Craig, you may conduct your cross-examination of Dr. Raja.
Thank you, Your Honor. Dr. Raja, good afternoon.
Afternoon, sir.
How long have you been an emergency room physician?
For 16 years, sir.
And you testified you're a professor at Harvard University, is that right?
Yes, sir.
And how long have you done that?
For the entirety of that 16 years, sir.
But in order to have that privilege of being a professor, your practice group actually pays Harvard University for you to have that academic appointment, is that correct?
Yes, sir. All of the physicians at the Mass General, the group pays a little fee to Harvard for their academic appointments.
How do you define emergent medical condition?
It's a condition that requires intervention to prevent the patient getting sicker or potentially even dying.
You've been retained as an expert witness by the Center for Reproductive Rights on at least 4 cases, correct?
Yes, sir. I think exactly 4.
And those cases involve laws in 4 different states, is that correct?
They do. Yes, sir.
And was it your opinion that the laws were unclear in every one of those cases?
Yes, sir. It was.
Have you ever testified or formed an opinion that a law putting some limits on abortion is clear?
I believe, sir, that when, yes or no question. Yes, I have.
In which case was that?
When I was testifying down in Texas, sir, I was cross-examined on the Massachusetts law and the medical exception there, and I explained that that was clear.
But you were not hired to opine on the Massachusetts law, is that correct?
No, sir.
Is that correct, or no, it's not correct?
Let me clarify. Yes, you're correct, sir, and no, I was not hired to opine on the Massachusetts law.
During the 16 years you've been an emergency room physician, you have never performed an abortion, correct?
That's correct.
You've never performed an abortion at any time during your entire medical career, correct?
Yes, sir. That's correct.
And when a patient comes into emergency room, the doctor must make an individualized determination on what's the appropriate treatment recommendation based on that patient's unique situation, correct?
Yes, sir.
And in fact, every patient's unique, and you have to create what I believe you call an individualized differential diagnosis for each patient, correct?
Yes, sir. That's correct.
What is that individualized differential diagnosis?
Essentially, it's based on the patient's specific presentation, the issues that they've come up with, as well as their physical exam and the testing that we've done, coming up with a list of things that may explain what's going on with that patient.
And so you started addressing it in that answer, but when a hospital or at the emergency room, when you see a patient, the first thing you do is to take a history from the patient, correct?
Yes, sir.
And then you conduct a physical exam, is that correct?
I do. Yes, sir.
And it'll take you 15, 30 minutes, maybe 45 minutes to do that history and conduct the physical exam, correct?
It may, sir. Usually in the 15 to 30 range.
And before you're able to see the patient and conduct that history and the physical exam, the patient may have actually been in the waiting room for some period of time before they see you, correct?
Unfortunately, yes, sir.
And if you're treating a patient with pregnancy complications, you might need to call an OBGYN, correct?
I may. Yes, sir.
That can add another 10 or 15 minutes to the time it takes to determine appropriate treatment, correct?
It may. Yes, sir.
So in your experience at the hospital you've worked at, it could be an hour or 2 from the time a patient with pregnancy complications enters the emergency room until that patient is able to get the appropriate treatment, whether that's seeing an OBGYN or other treatment. Is that correct?
Yes, sir. That's correct.
And in your time as emergency room physician, you personally might see 50 to 90 patients a week when you're seeing patients. Is that correct?
Yes, sir. That's right.
And about 5% of those patients that you see in the emergency room are pregnant, correct?
Yes, sir.
And of those 5% of patients who are pregnant, only about 5 to 10% of them come to the emergency room because of pregnancy complications, correct?
Yes, sir.
And of those who present with pregnancy complications, not all of them would require an abortion to treat their condition, correct?
You're correct, sir.
I want you to turn to one of your demonstrative slides that you used earlier. I believe this would be page 7.
I am there, sir.
So this page 7 lists choices for physicians treating patients in Idaho, and you list deny treatment, delay treatment, or provide care at the risk of criminal, civil, and licensure penalties. Is that correct?
Yes, sir.
But this assumes that the only appropriate treatment is for abortion, correct?
It assumes that abortion is one of the treatment options. Yes, sir.
But not every person who walks through the emergency room, not every pregnant woman who walks through the emergency room with pregnancy complications requires an abortion, correct?
You're right, sir.
So one of the options that you did not list here would be to provide treatment that is necessary that is not an abortion, correct?
That's correct, sir. These are choices for physicians treating patients for whom abortion may be an appropriate option. You're right.
So you ignored the other treatment options that might be available for an emergency room physician, correct?
No, sir. These are just the choices for that specific population.
And when you treat patients and determine the appropriate treatment recommendations, you exercise your good faith medical judgment, correct?
I exercise my best medical judgment, sir. As I mentioned earlier, I think that's pretty similar to good faith, but it's not something that I've ever used as a term when teaching my residents.
You testified at a deposition in this case, correct?
I did, sir.
I believe you have a copy of the deposition up there. I apologize, I need to figure out what exhibit number it is.
Are you talking about this white folder here, sir?
Yes, it'll be in one of those white binders.
AB 1037.
Thank you, Your Honor. Appreciate that. I'm missing the page number that would show that. You can turn to tab 37, exhibit
Yes, sir.
1037.
Actually, it looks like I may have misled because it looks like that's an expert report rather than a deposition. So,
So it might be right in front. Try 1030. Try tab 30.
I'm sorry, sir. It starts at 31.
Okay, look in the first binder, binder number 1. Binder
I
1
think
up
this
there.
is the only one I've got, sir. Thank you, sir. I appreciate it. At 30, sir?
Yes.
Yes, sir. I have it here.
So if you could turn to page 53 of your deposition, and so there's 4 pages on each page, and so each of those 4 pages has a page number in the bottom corner. So turn to page 53, please.
Thank you, sir.
And on page 53, could you please read lines 4 through 11?
Yes, sir. So it starts with your question. So in treating patients in the emergency room, the ER doctor, is he or she exercising his or her good faith medical judgment? There's an objection that called for speculation. And then I answered, in general, sir, when I practice medicine in the emergency department, that's what I do, and that's what I teach my residents to do. I can't tell you what every doctor does.
And then you testified today that emergency physicians must actually use their best medical judgment in considering and offering appropriate treatments, correct?
Yes, sir.
In fact, that's what you wrote in your report, is physicians must use their best medical judgment, correct?
Yes, sir.
You wrote in your, let me back up a little bit. You testified on direct examination about hyperemesis gravidarum. That is a condition of uncontrollable vomiting with pregnant women, is that correct?
It is, sir. Just the inability to keep anything down.
And it usually happens in the first trimester, correct?
Typically, yes, sir.
And that is usually treated without an abortion, correct?
Usually, yes, sir.
You also testified about previable prom during direct examination. You remember that?
I did, yes, sir.
Okay. And that can also be treated without an abortion, correct?
It can, sir, although abortion is an option.
And expectant management is an appropriate option as well in some cases, correct?
You nailed it, sir. In some cases, it is.
You wrote in your expert report that because of Idaho laws, quote, a physician might delay or worse yet, outright deny treatment to allow the patient's condition to further deteriorate closer to death to minimize the risk of their good faith medical judgment later being second guessed. Do you recall that statement that you wrote?
I don't, sir, but that sounds like something I'd write.
Okay, if you want to confirm, it's in your report, paragraph 31.
Thank you, sir. Yes, sir, I see it.
And did I quote that accurately?
Yes, sir, you did.
Now, you've provided opinions in some of those other cases. In one of those other cases, you testified about that good faith medical judgment is not ambiguous, and it is in fact clear, correct?
Objection. Relevance.
Overruled. You can answer.
I don't recall, sir.
I'll hand you a copy of the declaration that you filed in that case.
Objection, Your Honor. This is a different state, a different law than what's applicable here.
I think the point is to get at whether the witness views the term good faith medical judgment that is used in our statute as clear or unclear, ambiguous or unambiguous. And it seems to me that it's an inbounds topic, regardless of whether in a certain instance the language is used in another state's laws. So I'll permit the inquiry.
Thank you, sir.
So, Dr. Raja, you were hired to serve as an expert witness in the case of Blackman versus State of Tennessee, correct?
Yes, sir, that's correct.
You filed a reply declaration in that case in March of 2024, correct?
I did, yes, sir.
Can you please turn to paragraph 6?
I'm sorry, sir, I turned to page 6. 1 second. Yes, sir.
Okay, there is, towards the end of that paragraph, I guess it's I think the fourth sentence, second from the last, it starts with, while both serious worsening. Do you see that sentence?
Yes, sir, I do.
Please read that sentence.
While both serious worsening and serious threat could, considered alone, be ambiguous, that ambiguity is cured in section 63.6.222 because that statute provides that a physician does not violate the statute if she acts in good faith.
And you filed this declaration and signed it under oath, swearing to the truth of the matter asserted, correct?
I did, yes, sir.
And in this declaration, you also wrote that you believe that good faith medical judgment standard eliminates the fear of second guessing a doctor's judgment, correct?
Would you mind pointing out where that is, sir?
Yes, if you could turn to paragraph 13.
Yes, sir.
And you testified through this declaration, or wrote in this declaration under oath, that you believe that with a good faith medical judgment standard, quote, doctors would not hesitate to provide their patients with the full spectrum of necessary care, correct?
Yes, sir.
You also testified in the State versus Zarowski case, I'm sorry, Zarowski versus State of Texas case in the state of Texas, correct?
Yes, sir, I did.
And in that case, you testified that Texas law should permit physicians to act in their good faith, correct?
I'm so sorry, sir. I don't recall.
Okay, I'll hand you another document.
Thank you, sir.
Thank you.
Thank you.
And this is a copy of the Texas Supreme Court case opinion in that case. If you could, please turn to page 656. And Your Honor, for the record, this is 690 Southwest Reporter, 3rd Series, 644, Texas Supreme Court, 2024.
Thank you.
Yes, sir, I'm there.
And there's 2 columns on this page. If you could go to the very bottom of the first column.
Yes, sir.
And that paragraph talks about the Center for Reproductive Rights presenting 2 experts. And at the very last sentence of that first column, continuing on to the next one, it refers to the emergency medicine expert. And that would be you, correct?
I believe so. Yes, sir.
And could you please read that, that sentence that starts with the emergency medicine expert?
Yes, sir. The emergency medicine expert testified that confusion about the law is leading physicians to err on the side of not treating their patients. In that expert's view, Texas law should permit physicians to act in good faith.
Objection, Your Honor. He's not a lawyer, and also he needs time to review the document, familiarize himself with it.
Well, it's attributed a certain view to him, and I think it's fair game for, I suppose, both counsel to inquire as to whether that indeed was his view and whether the opinion fairly attributes it to him. But I don't think it's out of bounds to question him about a view that's attributed to him in a judicial opinion. Go ahead and continue.
Thank you. Is there any reason to believe that the Texas Supreme Court misstated your opinion?
No, sir.
So that was, in fact, the opinion you testified to in that case?
I'm sure it was, sir.
If an exception instead, so let's assume something. So if the exception in Idaho law instead read that Idaho physicians are allowed to perform an abortion for, quote, any emergent medical condition that the physician determined in his good faith medical judgment and in consultation with the pregnant patient poses a risk to that patient's life or health, including her fertility, would that be clear?
It seems more clear, sir. I'd have to actually see it in writing. I'm sorry. It was pretty quick.
Let me go ahead and provide you that in writing.
Thank you.
Thank you.
Handing you a copy of deposition testimony that you took in that Zarowski case we've been talking about in Texas. If you could please turn to page 36. And could you read, well, go ahead and read it to yourself. Read pages, lines 19, 36, line 19 through 37, line 8.
Yes, sir.
All right, so I'll rephrase my question now that you've had a chance to read a very similar, if not identical, almost identical question. So if the exception in Idaho instead allowed an Idaho physician to perform an abortion for, quote, any emergent medical condition that the physician determined in his good faith medical judgment and in consultation with the pregnant patient poses a risk to that patient's life or health, including her fertility, would that be clear?
It's more clear, sir.
You testified in this Texas deposition, but that would not be clear, correct?
Yes, sir. For the same reason I'm happy to explain now.
And the definition that I just read is what the plaintiffs are asking for the court to put in this case, correct?
I'm so sorry, sir. I don't actually know the details of what the plaintiffs are asking, but I'm happy to explain why it would be more clear, but not clear.
You've been paid tens of thousands of dollars by the Center for Reproductive Rights for your testimony in these cases, correct?
Objection. Relevance.
You've been paid tens of thousands of dollars by the Center for Reproductive Rights to testify in these 4 cases, correct?
Objection. He's talking about cases other than this case.
Understood, but the engagements, I think, have a relationship to one another and by the same engaging party. So it seems to me that it's fair.
You've been paid tens of thousands of dollars by the Center for Reproductive Rights to provide testimony in these 4 cases, correct?
I have, yes, sir.
Thank you. I don't have any other questions.
All right. Thank you, Mr. Craig. Ms. Dunham, any redirect?
Dr. Raja, you were just asked about your testimony in the Zarowski v. Texas deposition. Do you still have that in front of you?
Yes, ma'am, I do.
Would you please explain why the standard or the statement, any emergent medical condition that the physician determines in their good faith judgment and in consultation with the patient poses a risk to a patient's life and her health, including their fertility, why that is more clear?
Yes, ma'am. It is more clear in that it includes any emergent medical condition, and it's broader. But the reason that it's not as clear as it could be, as I explained in this deposition in Texas, was that it doesn't take into account the fact that non-life-threatening conditions, or conditions that are not immediately emergent, can progress to becoming emergent conditions.
Dr. Raja, you testified about good faith medical judgment and best medical judgment. Can you clarify what the difference is between those two?
Not entirely, ma'am, but I can try. As I said many times, when I teach my residents, when I talk to other emergency physicians, we talk about best medical judgment. But as I've testified to earlier, it seems like good faith is like that, is similar to that, but it's a legal definition that is not something that I use commonly.
And Dr. Raja, are there 2 medical exceptions at issue in this case?
Yes, ma'am, there are.
And what are the medical judgment standards in those 2 medical exceptions?
In one, it's a good faith medical judgment standard, and in the second, it's a reasonable medical judgment standard.
And which comports more with the national standard of care?
And as I've described, the good faith standard comports more, as I understand it, although it's a legal definition.
And counsel asked you about slide 7 in your demonstrative slides. Do you recall those questions?
Yes, ma'am, I do.
Are these the options that are available to physicians treating high risk patients with high risk pregnancies with emergent conditions?
Yes, ma'am, they are.
No further questions.
All right. Thank you, Ms. Dunham. Anything else for this witness, Mr. Craig?
No, Your Honor, thank you.
Dr. Roger, you may
Your
step
Honor.
down. Plaintiffs may call their next witness.
Thank you, Your Honor. Plaintiffs call Dr. John Wardell.
Afternoon, Dr. Wardell.
Good afternoon.
Go ahead, Ms. Dunn.
Good afternoon, Dr. Wardell. My name is Hannah Dunham, and I am counsel for plaintiffs in this case. Would you please state your name for the record?
John Wardell.
And what do you do for work?
I'm an OBGYN physician,
Where are you employed?
St. Luke's Health System.
What is your current position?
So currently, I just practice medicine. I stepped down from my leadership position toward the end of July, so I just practice gynecology this time.
And what was your most recent position before that?
So I was a service line medical director at St. Luke's and managing the women's service line.
And what was the date range that you were in that role?
So I started in February of 2021 and stopped in July of this year.
And what is your medical specialty?
So I'm the obstetrician gynecologist.
Are you board certified?
I am.
Would you please briefly describe your educational background for the court?
Sure. I went to undergraduate school in Chapel Hill at University of North Carolina, and I went to East Carolina University School of Medicine for medical school, and was able to do my residency training in Charlottesville at the University of Virginia.
How long have you been practicing medicine?
So since I moved here in 1991, so I finished training in 91, so since that time.
And has your entire practice been in Idaho?
As
Going back to your role as medical director of women's services at St. Luke's, what did you do in that role?
So, basically the service line medical director is designed to kind of help lead the physicians, ensure quality of care, safety, but also work on physician leadership and help manage and run the ambulatory clinics. So we're responsible for both inpatient and outpatient care.
And you mentioned a service line. What is a service line?
So it's really a governance structure that's designed to take care of a population of people, in this case, women's care.
And in your role as medical director, did you still see patients
I did.
for about how much of your time?
I was about 50% administrative and 50% clinical.
And in your role as medical director, for what facilities were you responsible?
So all the St. Luke's facilities that have inpatient or outpatient clinics, and that would include the major hospitals in Boise, Nampa, Meridian, Twin Falls, but also our smaller critical access hospitals in Mountain Home and McCall and Wood River. And then we have some other clinics at other locations like Fruitland.
And who are the obstetrics providers at critical access hospitals?
So at most of our critical access hospitals, those are family medicine physicians that do the majority of obstetrical care.
And how big was the team you supervised as medical director?
This is relevant, so I'm not sure how any of this is relevant to claims.
Category of demonstrating credentials at this point still? I'll overrule the objection. You can answer.
Thank you. It's a pretty broad team of people as far as physicians, probably 75 physicians in one form or another. Our service line at St. Luke's is a mix of independent physicians, employed physicians, and those who are in a PSA arrangement, so they're aligned through a professional services agreement. And then we also have a number of advanced practice providers, midwives, nurse practitioners, physician's assistants. And then, of course, underneath those at all the clinics, we help manage all the staff that are nursing staff and people who work in all the various facilities to provide that care.
And how did you keep tabs on what was going on with that large team?
Yeah, I'm just, I have luckily a large team that helped me. But there's lots of venues. We have online venues. We also have newsletters. There's weekly meetings. There's touch bases. Physicians can reach out to me or call me or text. And same with my administrative dyad, who I work with. So there's lots of opportunities for people to get feedback and to reach out to us for help or support.
Are you familiar with the laws at issue in this case?
Yes.
And what is your understanding of the two laws at issue?
Objection calls for a legal conclusion. Relevance, I'm not sure how his opinion or understanding is relevant.
All right, well, I don't know where the witness's testimony is going as a whole. Any testimony he gives about his understanding of the law would be regarded rather than as an authoritative legal interpretation, instead as a physician's perspective of how to navigate the legal circumstances. in terms of, I guess, the idea in the objection that the witness's testimony, I gather, I'm not sure if the objection was that the entire testimony of this witness is not going to be relevant, or if it was something specific to that. Was it just that question?
I believe his entire testimony will not be relevant.
I don't know what the whole testimony is, but.
So, Your Honor, he will testify to how St. Luke's treats patients with abnormal pregnancies, how the bans have affected that treatment, and how the bans have affected the MFM workforce who treat these high-risk patients. And, Your Honor, I understand your previous rulings on the physician availability issue, but as you heard this morning, MFMs are different. They are the doctors who are treating these high-risk pregnancies. The witness will testify that every high-risk pregnancy is likely to see an MFM at the MFMs that he knows of or that he supervised at some point in their pregnancy. And the number of MFMs in the state directly impacts the ability of high-risk patients to get the care they need. So there's a straight line from the abortion bans to the number of MFMs to the care these high-risk patients are able to receive, which is relevant to Claim 3.
So the court has previously said that it is not relevant to be testifying to the harms to the healthcare system in general or as a whole, and that's exactly what this goes to.
All right. Well, that, I mean, I can look at Claim 3 in the case, and I don't see that theory in Claim 3 as pleaded, that the law has the secondary effect of bleeding the state of providers such that medical care won't be available. How it reads to me is that certain abortions are illegal, and that as a result, women in need may not receive them. And what we're talking about is the rights of, in Claim 3, those women to abortions under those circumstances. I guess that's how I see the claim.
Your Honor, if I may, plaintiffs in their complaint alleged a number of allegations regarding physician, availability of physicians to care for these high-risk pregnancies. You've heard from two IFP members who work within Dr. Wardell's service line. You've heard from an MFM, you'll hear from another MFM, and the state has raised maternal health as a compelling interest for these bans or these laws, and we think this testimony about how the bans affect the availability of MFMs is directly relevant to maternal health.
If they're trying to present it as rebuttal for our case, then that would be more appropriate to come in as rebuttal as opposed to their case in chief.
All right. Well, I think what I'm going to do, I've indicated my view on the scope of the case, the scope of the claim at issue. What you're describing seems to me to be outside the scope. Nevertheless, the doctor is here, and I think what I'll do is I'll indicate that my ruling has been throughout the trial that that's not part of this. That's not part of the claim. That we're here to adjudicate, not a viable theory of proving the claim. But I'll permit you. So if that's what the testimony goes to, at this point, I would conclude that it's not admissible. Now, he's here. You want to conduct this entire examination on sort of an offer of proof theory, and we can litigate through the course of the post-trial motions, not motions, but proposed findings and conclusions, whether this evidence should be considered and for what purpose. We can do that. So on that theory, you want to go forward, that's fine.
And then, Your Honor, just be clear, I will not be objecting on relevancy. I will assume that is a continuing objection, and so I will limit my objections to other grounds.
That's fine with me. Thank you.
Thank you. So, Dr. Wardell, what is your understanding of the laws at issue in this case?
So basically, in summary, the total abortion ban really makes it against the law to provide an abortion for any reason except to prevent the death of the mother.
And is there another law at issue in this case?
Yeah, the Fetal Heart Rate Act is also, in play to some degree. It's been pretty much superseded by the total abortion ban, but it did give some limited health exceptions in that law. But there's a civil penalties section of that law that could come into play if you were charged with a crime.
And do these laws as written present concerns to you?
Absolutely.
What are those concerns?
Well, the main concern is that physicians were never trained to wait and to prevent the death of a patient. That's just not how we were trained. We were trained to intervene early to try to prevent complications and problems that could occur down the line. And waiting till near the end or till someone's sick just doesn't comport to us. It isn't right.
And how do the laws impact your ability as a physician to apply the exceptions to real-world patient scenarios?
Yeah, so, this spectrum of disease and illness is very wide. Someone can present with something that they have an acute problem, but yet they're not very ill yet. But
Object his expert testimony. He was also not disclosing expert testimony. He's now providing his opinion on medical conditions of people presenting to the physicians.
Honor, he's a practicing physician who sees patients with high-risk pregnancies. He's testifying to his personal knowledge.
He's testifying to an opinion.
Well, ultimately, isn't it in the realm of opinion testimony? Or, I mean, it seems to be to me. All right, let's have a new question.
Have you perceived any physicians having difficulty in providing patient care under the bans?
yes,
Objection calls for expert opinion.
Raised in that way, it seems to be asking for factual information as opposed to opinions. So I'll overrule the objection. You can answer.
I'll rephrase the question.
Have you perceived other physicians having difficulty in applying the bans to real-world patient scenarios?
Yes.
What difficulties do you perceive for those physicians?
Yeah, they're
Active foundation to show personal knowledge.
Asking for his perception.
All right. I think I'm going to overrule the objection. This just triggered a recollection of something I was supposed to let you know about, Mr. Craig. It's just that your objections at times are difficult to hear for those appearing on, or those paying attention via the live streaming, and I understand may be difficult here for some others in the courtroom at least. So perhaps speak up a little bit on your objections. I'm going to overrule that one. All right. If you restate the questions.
What difficulties do you perceive for those physicians?
physicians are having a hard time deciding when to act.
Briefly, how have the abortion bans impacted women's services at St. Luke's?
Yeah, it's been a bit of a problem. I'd say the biggest impact is to the team, and the team are all the frontline physicians and providers to care for patients. But it's not just the physicians; it's the remainder of personnel at the hospital that provide care. It's our nursing staff, it's OR personnel, it's anesthesiologists, it's pharmacists, all people that feel they're at risk when providing this care. So that's number one. Recruitment and retention has been really challenging. We really had to pull out the stops and focus on trying to recruit and retain physicians. But the biggest thing for us is really the burden, the tremendous burden this has been for the hospital system, the wasted resources and talent that have gone into managing this. And During a lot of our committee meetings in 2022 and 2023, up to 50 people were meeting every week trying to help lay out guidelines and resources and provide support to physicians and staff. And this still goes on today. It really hasn't ended. I mean, I still get calls from physicians and other people nervous about the care they're providing, and I've already stepped out of my leadership role. There's someone else that took my place. So it has an enormous impact on people in my service line.
I'll object to the answer to the extent he relayed hearsay testimony from what other people have been telling him.
Okay, understood. I'm going to overrule the objection. You can continue.
How often does a pregnant patient, on average, present at St. Luke's with an abnormal pregnancy?
Yeah, so, the best answer we can give is somewhere between 25 and 35 patients per week. And this is in the whole St. Luke's health system. And this really involves almost every abnormal thing that you could imagine, all the way from normal miscarriages, all the way to ectopics, abnormal pregnancies, lethal and life-limiting fetal anomalies, all the way to fetal demises, to complications discovered later in pregnancy, the preterm premature membranes patients we talked about. So lots of different patients, but those who present with acute complications about 30 times a week. Yeah.
And how often have patients within the service line you supervised been denied abortion care despite their pregnancies posing a risk to their health since the bans went into effect?
Objection, lack of personal knowledge, lack of foundation. And again,
He managed the service line. He's aware of, he has personal knowledge of this.
Overruled. You can answer.
Yeah, so basically 100% of patients with lethal or severely life-limiting fetal anomalies have not been able to get care in the state. So 100% of all those patients. And then patients who really do have a complicated mid-trimester problem that where termination is appropriate or necessary, at minimum, they get delay of care. And some of them have required transfer or transport out of state.
And can you give me an example of a case where there was a delay in delivering care to the patient?
Must I answer specifically, or can I answer in a generality around a group of patients?
Let's start with a generality.
Yeah. So, we've two major groups of patients. So those that have had preterm premature rupture membranes, which I suspect has come up so far, that is a situation where often we would manage those patients at a far earlier point, and there's often a delay in care in those patients. And often increased testing, increased imaging, increasing a number of labs, and discussion and reaching out to legal counsel to decide how to proceed. So all those patients have delayed care. It may not be critical delay of care, but everyone has delayed care.
And what is your understanding of what happens to these patients?
It could vary tremendously. In some patients who are stable enough and who desire an alternative option than available here, they could be referred out of state. Some can go by private car. Some may be directed right from their primary care physician or their obstetrician gynecologist and never involve maternal fetal medicine. Some do end up all the way in Boise where their care is more carefully scrutinized, and those patients actually do require transport out of state because we feel we can't act at an early enough point. Others are cared for emergently, just like we always have. So all various options could occur.
And focusing on patients who have been transported out of state, does transporting patients out of state resolve your concerns about patient care?
No.
Why not?
Well, it's dangerous, it's expensive, things can happen during transport. So if somebody is supposedly stable and then they're being readied for air transport and then something happens in flight, so air transport isn't without risk.
What specialties that you supervised have been most impacted by the bans?
Well, everyone who has a frontline role and sees patients who are pregnant in emergent situations. So essentially, MFM is the most severely impacted, but certainly our generalist OBGYN teams, our family medicine obstetricians who work in our critical access hospitals, they often have to act acutely to care for people. Emergency medicine physicians, they often have to do or administer care in our emergency rooms. Yeah, and then certainly some other specialties, but those four in particular.
Would you please briefly describe how MFMs function within Idaho's maternal health care system?
Yeah, so Idaho's a big state and predominantly rural, and most of the MFMs have always existed in the Treasure Valley anyway and work predominantly in Boise, Nampa, Meridian, and maybe in Twin to some degree in a limited sense. So the highest risk patients end up coming to the two major facilities, St. Al's or St. Luke's, where we've had MFMs on staff to help consult or acutely manage or actually deliver those patients.
And do MFMs interact with obstetrics providers at the critical access hospitals that you supervised?
Yes.
And how many MFMs are required for your service line?
Yeah, so the design for our service line has always been 6.5 to 7 FTEs.
And how many MFMs were working at St. Luke's before the bans went into effect?
Yeah, so 5, but we hired a 6th physician that actually started September 1, so literally started just days after the bans went into effect.
And do you know if any of MFMs who left because of the abortion bans?
Yes.
Who are they?
Objection, relevance. I mean, I think even to the court's limited stuff, even this is irrelevant, even more.
All right, well, you can have that additional objection, and you can go ahead and answer.
Yeah, we lost 2 of our wonderful young maternal fetal medicine physicians, Dr. Kylie Cooper and Dr. Lauren Miller, who left in 23.
And do you recall when in 23 they departed?
I think it was April and July, I think. 23.
What was the impact of Dr. Cooper leaving your service line?
The first departure, everyone was pretty sad. We lost a colleague that we all respected. She was felt well loved by patients, really had a connection with Idaho, wanted to stay, but just felt very unsafe practicing here.
Did you try to retain Dr.
Hearsay.
All right, sustained.
Strike to the extent the court allows it in.
As admissible evidence, the doctor's recitation of the particular concerns stated by to him by the other doctor as to why she is not willing to practice here anymore.
Do you have reason to believe that Dr. Cooper left because of the bans?
Objection, hearsay.
Absolutely.
I suppose you got to take me through why that wouldn't be hearsay.
Well, there's a present sense impression. Dr. Cooper told him that she was leaving because of the bans at the time that she left. It's also a mental impression, her motive for leaving the state.
That's not a present sense impression. It's the most expansive view of that rule I've heard, I think.
State the objection.
Did you try to retain Dr. Cooper?
Yes.
Were you successful?
No.
What was the impact of Dr. Miller leaving your service line?
That was harder for the team. Losing essentially our only other young physician besides Dr. Harmon, we were very worried that we couldn't maintain the service at our hospital anymore. If you lose too many physicians, you can't recruit because no one will come to a facility that doesn't have enough physicians to cover call, and so we were very worried. Lauren was also one of the smartest, brightest physicians I've ever worked with. She was amazing, and so I lost a colleague, but also a close friend. And so to everyone, there was a lot of grieving once we lost our second physician.
And did you try to retain Dr. Miller?
Yes.
Were you successful?
No.
Since the bans went into effect, have you had any difficulty finding enough MFMs to effectively optimize care within the service line?
Yeah, it's been a challenge. I will tell you, we prioritized this recruitment at the highest level of the hospital system because we just couldn't lose our ability to take care of the higher risk patients. So we pulled out all the stops to try to recruit physicians.
And from your perspective, how did departure of 2 of the 5 MFM specialists or 6 MFM specialists at St. Luke's impact patient care in Idaho?
Objection calls for speculation.
Overruled. You can answer.
Question again.
Sure. From your perspective, how did departure of 2 of the 6 MFM specialists at St. Luke's impact patient care in Idaho?
In all honesty, we were pretty lucky. The remaining physicians really stepped up. They took extra call. No one who was remaining really wanted to watch the program that they had worked so hard to build fall apart. We needed 6 locums physicians over that year, so it was very costly and expensive. We worked hard to recruit and retain new folks. We provided retention bonuses to the existing physicians to help them stay. Many were showing signs of wanting to depart from our hospital system. And then we spent a lot of time on recruitment.
And are you aware of any other changes to the statewide MFM workforce since the bans went into effect?
Yeah, in 2023, I know that St. Alphonsus lost all 3 of theirs to leaving the state or early retirement.
Your Honor, I'd like to show the witness Plaintiffs Exhibit 318, which has already been admitted into evidence.
Sorry. Oh, I see. All right, I see. I don't recall whether 318 was admitted, but it's the same document as Plaintiffs 1057. Perhaps it was admitted separately. I'm not sure.
Apologies, Your Honor. Should I have the witness look at Defendant's Exhibit 1057?
I have no objection in looking at 318. It appears to be the same document on my just quick review.
Admit it too, I suppose, even though we don't necessarily need 2 of the same as maybe the most expedient way to deal with this issue.
If we admit it as well, there's the email issue for Dr. Corrigan. Thank you.
Email address will be redacted. Exhibit
Thank you, Your
318 is admitted. You may proceed.
Thank you. May I take a moment to look at it?
You ready?
I am.
Okay. What is this document?
So this is a letter to me from Emily Corrigan.
And do you recall receiving this email?
I have a memory of it at the time, yes.
I'm going to direct you to the second paragraph of this email. Would you please read the first 2 sentences?
As you probably know, there's an ongoing mass exodus of MFM and OBGYN providers from St. Al's. I'm sure that Luke's OB and MFM services are already seeing increased demand due to the decreased availability of appointments at St. Al's.
Does this align with your understanding of the changes in the MFM workforce in Boise after the bans?
Yes.
And does this comport with your understanding of the effects on patient care due to those changes in the MFM workforce?
Objection, leading.
Overruled. You can answer.
Again, please.
Does this comport with your understanding of the effects on patients due to those changes in the MFM workforce?
Yes, and I think what I want to call out is Emily's email is not unusual. I've received lots of calls from folks trying to figure out how to navigate the complexities, whether to stay employed in their current organization. We were losing physicians as well, and so there was a lot of people leaving and looking to migrate around the system and around our area or out of the state. So yes, this is exactly what was going on for much of 2022 and 2023.
Okay, you can set that aside. Did those departures strain your resources at St. Al's?
You mean at St. Luke's?
Apologies, at St. Luke's.
You want to rephrase that? Sorry.
Of course. Did those departures strain your resources at St. Luke's?
Yeah.
How so?
Well,
Object, asked and answers. He's already testified about what they had to do to navigate this.
And just to be clear, I'm asking about these departures from the statewide MFM workforce, including St. Al's, not just St. Luke's.
Why don't you restate the question?
Did these departures of MFMs from St. Al's strain your resources at St. Luke's?
absolutely.
How so?
Well, our physicians at St. Luke's had to step up and provide some support and resources for St. Al's, as well as we did throughout the state. There were lots of people reaching out to us at the time, and we were fortunate. We are the largest healthcare system in Idaho, and we had some resources and availability that other places didn't have. We tried to freely provide those resources and support to physicians across the state. So yes, we did to St. Al's as well.
As medical director at St. Luke's for the Women's Services Line, did you participate in recruiting MFMs?
Yes.
Do you know how many people applied for MFM positions prior to the bans?
Prior to the bans, are you asking on a yearly basis, monthly basis?
Do you know how many people applied for a given MFM position prior to the bans?
Not exactly, but we planned far enough ahead prior to this time that we would work hard to try to identify the need, and then we put an opening, and then often we'd have several applicants, and it was pretty easy to find a physician at that time.
And why was it easy to find a physician at that time?
Because Boise is a pretty desirable place to practice. The St. Luke's practice is a unicorn practice, it really is. Much of MFM care around the country has gone consultative, where physicians actually aren't delivering babies or providing direct care in the hospital or taking care of folks. They're just providing consultative services. This practice allows the physician to actually do the full breadth and spectrum of what they were taught. So it's a unicorn practice. It's very desirable, and the group is good. It's solid. It's strong. So it's a good place to come, not to mention the lifestyle in the area.
And how did the number of applicants for MFM positions change after the bans went into effect?
It was much harder. There were less applicants.
And briefly, can you remind the court what St. Luke's has done to address this difficulty?
Yeah, so after Lauren and Kylie left, we were very worried about the lone young physician, MFM, and our 3 senior physicians that were left, who were all trying to slow down and potentially step into retirement. They showed signs of potentially not wanting to remain and keep working at that point. Everyone was pretty scared. So we did some retention bonuses for those physicians, and we upped the ante for our recruitment incentives for new physicians.
And is that sustainable for St. Luke's in the long term?
I don't know, but it worries me long term.
Did St. Luke's develop any guidance around the bans?
Yes.
Were you involved in creating that guidance?
Yes.
Who else was involved in developing that guidance?
We had a huge team of people, so we formed a Women's Health Med Ops Committee that was actually formed similar to how we did our response to COVID at the beginning of the COVID crisis. So we had executive leadership, we had our chief medical officers for all the facilities, we had physician experts, we had legal counsel, government affairs people who were part of this committee, and project management support and some nursing staff. And, we met weekly through much of 2022 and 2023.
Were there any challenges in developing that guidance?
Yeah, it was hard. We were trying to keep patients safe and keep providers safe and just try to navigate the complexity of these laws, which were very challenging to administer in a way to keep both groups comfortable and provide support. And
has the guidance resolved all problems with complying with the bans at St. Luke's?
No.
Why not?
Well, it's that continuum of care. It's that spectrum. Every patient's different. I mean, some patient can present and be stable and 2 hours later be very ill. Other patients can go months and with certain presentations. So it's just hard to wait until someone is acutely at risk of dying before you have to take care of them.
Do the bans only affect doctors in your service line?
No, they really apply to everyone who helps care for the patient. So an anesthesiologist that puts a patient to sleep for a procedure that maybe someone could say was wrong or inappropriate, they're at risk as well.
And what changes to the bans would be helpful to you in your practice?
Well, a complete and unobstructed health exception, that's number one. Second, we need to be able to provide terminations of pregnancy, if appropriate, to patients with lethal and life-limiting fetal abnormalities. We have to quit criminalizing healthcare. It makes it very difficult and dangerous to care for patients. And we have to allow physicians to provide evidence-based care, because we expect nothing less in any other area of medicine. Why would we expect less in our service line?
Thank you. Thank you, Dr. Riddell. No further questions.
All right, thank you, Ms. Dunham. Cross-examination, Mr. Craig?
Yes, Your Honor, I'll be brief, but I just want to make it clear that I don't want any of this cross-examination to be considered. This is all under the assumption that his testimony is irrelevant and not being admitted. And so
It's been presented as an offer of proof. Should the court be persuaded ultimately to reverse course on the notion that the claim at issue, Claim 3, as to whether that claim encompasses the idea that the medical system, the relevant portion of the medical system is en route to collapse and is going to undermine the constitutional rights of women to receive care in that way. So your cross-examination will be without prejudice to your position on that point. And of course, should I wind up reversing course, then you'll have had the opportunity to have whatever information you elicit on cross considered as well.
thank you, Your Honor. Dr. Wardell, can you define emergent medical condition?
So that's difficult. If you think of an emergent medical condition, there are times when people are very ill and need care absolutely emergently. Ruptured appendix, myocardial infarction. You can think of conditions which you expect us to act immediately. So that would be my definition of emergent medical condition.
Okay. Could you repeat that? You said it was difficult, but it would be situations in which you have to act quickly? I'm not sure. Sorry, I wasn't sure I was following. Can you repeat? What is your definition of emergent medical condition?
So it's a condition that, if left untreated, could result in significant morbidity or mortality. An example being myocardial infarction, ruptured appendix, something that requires emergent medical care.
Are you aware of any Idaho doctor who has been prosecuted for violating the abortion ban, the Defense of Life Act, since it went into effect?
No, but that's limited solace. Doesn't help.
Are you aware of any doctor who has been subject to professional discipline since the Defense of Life Act went into effect? What is obstetrics?
It's the branch of medicine that cares for pregnant women.
And you've not practiced obstetrics for over 13 years, correct?
Correct.
In April 2022, St. Luke's had 5 maternal fetal medicine specialists, correct?
Correct.
And in July of 2024, St. Luke's had 5 maternal fetal medicine specialists, correct?
Correct.
And as of August or September, well, let me rephrase. How many do you have now?
Yeah, so we have 7 physicians on staff now, with 3 of our senior physicians in the process of stepping down and slowing down.
So when you testified let me back up, lay a foundation. You testified at a deposition of this case in July of 16th, 2024, correct?
I did.
And you were designated as a representative under Rule 30b-6 for St. Luke's Health System, correct?
Yes.
And when you testified in July, you indicated that you had 3 that were in the process of being hired. Is that correct?
So one hasn't completely, is not completely finalized, but that would be for September of 2025. But the 2 physicians that are on staff now just started in September, so.
So did that change? I believe you may have testified at the deposition that they were all supposed to be on staff by September 2024. Did that change?
So the 7 people includes 2 physicians that have been hired and started in September. We are in process of negotiating for another physician for September of 2025.
So as of today, you have 7 MFMs. As of September 2025, you'll have 8 MFMs, assuming nobody leaves.
Well, it's almost certain we will, people are stepping out. We certainly won't have 8 full-time equivalents because people are just part-time.
Of the OBGYNs in Idaho, do you know what percentage perform abortions?
So what type of abortions are you referring to?
Any abortions?
Pretty much 100% of physicians that provide care in Idaho have provided an abortion as is determined and defined under the Total Abortion Act, because we take care of patients who still have a heart rate with an active miscarriage. We take care of patients that we've had to terminate for all a host of reasons. So they were not elective terminations of pregnancy, as you might note, but everyone has to take care of those patients. And so every single physician.
I'll hand you a copy of your 30B6 deposition transcript, or I'll ask the bailiff to hand you a copy. You turn to page 68, please.
68 refers to the small page.
Correct. Yes,
Okay.
each page has 4 pages on it. And actually, the question is on page 67. So if you could,
I find it.
okay,
I
so
know
if
where
you
it is.
could read page 67, line 23 through page 68, line 5, please.
So that answer was defining my answer to perceive that you were talking about elective terminations of pregnancy. So I will read that. Do you know what percentage of OBGYNs conduct abortions as part of their practice? To where are you speaking? Across the country or in the state? In Idaho? Very few. Very few OBGYNs conduct abortions as part of their practice. Yes, but I couldn't tell you exactly how many. I can just tell you locally the ones that have in the past, but very few. So these answers were all my perception that you were talking about elective terminations of pregnancy, not
So-
management of complications of pregnancy.
So there's a difference between elective abortions and non-elective abortions then?
So we can probably get into that discussion if you want. I mean, you can define medical terminations of pregnancy, terminations that are required to manage and take care of the health or life of a pregnant woman. And then elective terminations might be something that they may choose for themselves for a host of different reasons that we may or may not be aware.
Are you familiar with the term therapeutic abortion?
Sure.
What's a therapeutic abortion?
So that can have various definitions. So therapeutic abortion could be an elective termination. It also could be a termination that had to do with a perceived fetal anomaly or genetic abnormality.
Does St. Luke's have a therapeutic abortion policy?
You don't have a policy using that term.
Do you have a policy that would encompass your definition of therapeutic abortion?
I'm not sure what you mean a policy.
Does St. Luke's have a policy on when abortions are allowed?
Policy on when they're allowed is according to the law right now. The law says that no abortions are permissible unless to prevent the death of the pregnant woman.
And what was the policy before the Defense of Life Act went into effect?
We didn't have a policy because it wasn't against the law. It wasn't a policy.
You had no policies at all regarding when St. Luke's physicians could or could not provide abortions?
No, but there were general guidelines on where and what facilities abortions could be performed in, but not a policy per se.
Familiar with the EMTALA federal law?
Ma'am,
And how does that affect how St. Luke's handles emergency patients presenting to the emergency room with pregnancy complications?
yeah, that's been a challenge. And so I think to comply with EMTALA, and we've given guidelines to our physicians in that respect, we tell physicians that they have a little bit additional protection if they're managing patients acutely and if in an emergency medical facility, so labor and delivery or our emergency departments, and only if stabilizing treatment has not been already provided. So a patient who has been admitted and stabilized doesn't have the same protection as somebody who is now in an observation status. So there was lots of nuance around how and when we could care for these patients.
St. Luke's has been actively involved in that United States versus State of Idaho lawsuit regarding EMTALA, correct?
That's maybe a question for our attorneys, yeah.
Are you familiar with the fact that St. Luke's has filed amicus briefs in those cases before both the Ninth Circuit and the U.S. Supreme Court?
Objection, Your Honor.
They filed an amicus brief? Yes.
All right.
He's not an attorney. He does not have personal knowledge. This is also outside the scope of the direct.
Well, I think the answer is harmless. I'll allow it to stand. You may ask another question.
Do you know how many MFMs, maternal fetal medicine specialists, are at St. Alphonsus Hospital?
Today,
Yes.
to the best of my knowledge, they had one full-time person. I think a second one has been hired recently, but I don't know when they started.
Do they have any part-time?
I think one of their existing physicians has helped cover some call, but I don't know how often, and so I don't have line of sight to that.
Do you know if there's other MFMs in other parts of the state?
So there are no other practicing MFMs. There is a visiting MFM from Spokane that I know travels once or twice a month to Coeur d'Alene, but they do not provide any inpatient services or actually see patients. They just provide consultative services.
So you were asked questions about Exhibit 318, the email that Dr. Corrigan sent to you. Did you offer Dr. Corrigan a job?
We did not.
Thank you. I don't have any other questions.
All right. Thank you, Mr. Craig.
No redirect, Your Honor.
Okay. Thank you, Dr. Wardell. You may step
Thank
down.
you. Yeah.
Let's see. We've been going about an hour and 15 minutes. I suppose we could take a break now, depending on ballpark length of time you might have for your next witness. What might we think that will take?
I think the direct would be about 30 minutes.
Probably just as well to take a short break now rather than wait that out. So we'll take 15 minutes.
All right.
Please be seated. Plaintiffs may call their next witness.
Plaintiff's called Duncan Harmon.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Good afternoon, Dr. Harmon.
Good afternoon.
Go ahead, Mr. Herron.
Good afternoon. Please say your name.
Duncan Harmon.
Are you employed?
Yes, I'm currently employed.
What is your profession?
I'm a maternal fetal medicine physician
Where?
here at St. Luke's in Boise, Idaho.
How long have you been practicing medicine in Idaho?
I've been practicing medicine in Idaho approximately 2 years.
Where did you practice before then?
Prior to that, I spent 3 years in Portland, Oregon for a maternal fetal medicine fellowship.
When you completed your fellowship in Oregon, why did you choose St. Luke's?
My wife and I fell in love with the Pacific Northwest. We're originally from Birmingham, Alabama, and we very much enjoyed the region, and through some professional contacts got plugged into the group at St. Luke's, came and met them, very much enjoyed the collegial environment here, and so was recruited to come and have really enjoyed our time here so far.
When did you sign your contract to join St. Luke's?
Approximately the fall of 2021,
When did you actually start practicing at St. Luke's?
August of 2022.
When you started practicing at St. Luke's, were Idaho's abortion bans already in effect?
They were in effect, yes.
What does your work as a maternal fetal medicine specialist at St. Luke's involve?
We do total prenatal care for high-risk obstetric patients. We see consultations for either maternal or fetal conditions in pregnancy and coordinate multidisciplinary care depending on the specific condition.
Can you give me just a couple of concrete examples of maternal conditions that you treat?
Sure. Some of the most common are hypertension, diabetes, type 1 and type 2, that may involve patients who are on insulin pumps, patients with autoimmune conditions like lupus, patients who have had solid organ transplants, patients who have multiple medical conditions that make their pregnancies much more complex.
When you were practicing in Oregon before you moved to Idaho, were you able to offer your patients the full spectrum of care?
Yes.
Did that include pregnancy termination?
Yes.
Are you able to do that in your practice at St. Luke's?
No.
Why not?
Due to the total abortion ban, there are many medical conditions and nuances where it is unclear as to whether we could proceed with a medically indicated termination of pregnancy. And so oftentimes those patients need to be referred out of state for that pregnancy care.
Are you familiar with the medical exceptions at issue in this case?
Yes.
Do you find those medical exceptions to be clear in your clinical practice?
No.
What's vague about the exceptions to you?
Currently, as the state law, as I understand it, is that the exception for termination of pregnancy is in my best medical judgment to prevent the death of the mother. However, there are many clinical scenarios where my crystal ball is cloudy. I don't know what the potential risk of death is, but I know that there's a significant risk of potential health complications for the mother, and it's unclear as to whether I can proceed in those scenarios.
Have you ever seen any guidance from the state of Idaho about how to interpret the exceptions?
No, I have not.
Have any Idaho officials?
No.
Objection, relevance.
Overruled.
Have you looked for such guidance?
I certainly have listened in to the Supreme Court case arguments by the state to try to better understand their thought process, but I have not directly requested clarification myself.
Dr. Harmon, if you determine that an abortion is necessary to prevent a pregnant woman's death, would you have any concerns about moving forward and providing abortion care in reliance on the exception?
I would, yes.
What would your concerns be?
It's not simply just me that is involved in a procedure to end a pregnancy based on maternal or fetal indications. It is a conglomerate or team effort. It includes nursing staff in the operating room, anesthesia staff, support staff, myself, an ultrasound technician. And so there are multiple members that need to have their concerns addressed and assuaged before we could all kind of as a team take care in participating in a procedure to care for a patient.
And do you have any concerns that your medical judgment would be second guessed?
Yes, absolutely.
Dr. Harmon, do you have an example about how the abortion bans have affected your treatment of pre-viable PPROM patients?
Yes.
Relevance, Dr. Harmon is not a plaintiff, and neither is whichever patient he's going to be testifying about.
Overruled. You can answer. Well, he did answer yes. You can ask
my
a follow-up
apologies.
question.
I'll
Can
try
you
to pause.
tell me about one of those patients?
Objection, relevance.
Overruled.
Since my time at St. Luke's, I've taken care of many patients with pre-viable PPROM. In a specific instance I'm thinking of was a patient who had been diagnosed with PPROM at approximately 15 weeks gestation. That diagnosis was in the emergency room, and so the patient was referred to me in the outpatient clinical setting. As is common, we confirmed the diagnosis with both ultrasound and a physical exam. In this particular scenario, there was no fluid around the fetus nor fluid within the fetal stomach. Fluid is vitally important for the development of the fetal lungs. And at such an earlier gestational age, we need to have a frank discussion about the potential implications of PPROM just for the outcome of the fetus if the pregnancy continues.
Object to the extent it's what he's testifying about is expert testimony. He's not been disclosed as an expert witness.
All right. Well, as I understand things, he's speaking to an episode with a particular patient in which he was engaged, and it would appear to be fact witness testimony on the whole. I'll overrule the objection.
At the same time, I need to discuss the potential implications to the maternal health, and so I reviewed all of these things with the patient in detail. Those consultations take 60 to 90 minutes to kind of go through all of the data and explain to the patient the potential risks and offer her basically two options: termination of pregnancy or what we call expectant management, meaning to try to get as far along in the pregnancy as possible to attain a healthy pregnancy outcome.
So let me just stop you there. Was the patient stable?
Yeah, the patient had no signs of bleeding, labor, no vital sign abnormalities, and no clinical signs of infection.
So what happened next?
Based on her clinical stability, we discussed options of expectant management or termination, and after a very thoughtful discussion and consideration from the patient, she expressed a desire for termination.
And then what happened?
She was appropriately referred to a higher level of care as I could not provide that medical treatment within our state.
Was she discharged?
She was neither admitted nor discharged. We only saw her in the outpatient setting.
What are the, were you able to provide termination?
No.
What did the patient tell you that she planned to do?
She planned to seek care out of state for termination services.
Objection, hearsay, move to strike.
It's 803.3 statement of the declarant's state of mind, such as motive, intent, or plan.
All right. You may respond if you like, Mr. Craig.
Your Honor, typically that's not, this is being offered for the truth of the matter asserted that she went out of state to get an abortion, and that's not what the intent exception is intended to get to.
Well, it's a hearsay exception, which no exception would be necessary if the matter weren't being offered for the truth, and the exception on in this instance would appear to apply. So I will overrule the objection.
And do you know whether she actually did seek abortion care out of state?
Yes, I do.
She did?
Yes, she did.
What risks, if any, did that patient face in having to travel for care?
Objection calls for speculation, calls for expert testimony.
Overruled.
I reviewed with her the potential risks of precipitous labor or quick onset of labor. The placenta can separate, what's called placental abruption, and lead to significant bleeding or hemorrhage. Signs of infection like fever, significant tenderness in her abdomen, and those things can all have very quick onset. So in a duration of a 4 to 5 hour car ride, those things can occur while she's driving down the road. And so she should seek immediate care to the closest medical facility that she has. But if she's in an airplane, that may limit, or she's not in near access to a healthcare facility, that could severely put her health at risk.
Has St. Luke's had to transfer any patients out of state due to the abortion bans?
Objection,
Yes.
lack of foundation, those to his personal knowledge.
All right. Well, I assume I assume you're going to attempt to show how the witness knows through further questioning. I'll allow the answer to stand. It won't mean anything unless there is further elaboration. So, go ahead.
Dr. Harmon, can you give me an example of when St. Luke's has had to transfer a patient out of state due to the abortion bans?
I've personally transferred a patient out of state from St. Luke's.
What happened in that circumstance?
In this particular circumstance of a twin pregnancy, we had placed a what's called a cervical cerclage. It's a stitch that we place in the cervix in someone who has a shortened or dilated cervix. The purpose of the cerclage is try to maintain the pregnancy to get further along and reduce the risk of a premature birth. In this particular instance, this patient was admitted prior to the limits of viability with vaginal bleeding, and we were concerned about a multitude of potential reasons for that bleeding. She was stabilized, observed in the hospital for multiple days, but continued to have small bouts of vaginal bleeding. After consulting with our NICU colleagues, she very much expressed resuscitation of her twins at a specific gestational date, but she was weeks prior to that date. There was concern that should her clinical stability worsen, a termination may be indicated, and she was very concerned about that not being an option for her, only in a scenario of a massive hemorrhage, i.e. her risk of death is imminent. And so thus, we transferred her out of state so that a decision for termination could be made earlier rather than a much later threshold of her risk of death.
Were you able to apply the medical exception to that patient? Let me rephrase the question. Was an abortion necessary to prevent that patient's death?
At the time of the decision-making for transfer, no, an abortion was not necessary to prevent her death.
What were the risks to that patient if the patient chose expectant management over abortion?
The potential risks were that she have rupture of her bag of water, that she develop ongoing bleeding requiring a transfusion, that she have massive bleeding requiring a massive transfusion and taken to the operating room for a major abdominal surgery to evacuate the contents of the uterus and stabilize her, and thus potentially losing the pregnancy.
So how do the abortion bans impact that patient's care?
Because of the potential threat of a significant risk to her life, the patient, through informed decision-making, felt that she could not receive appropriate care here, and so in a shared decision-making process, we elected to transfer her out of state so that if she had clinically worsening status, but not yet at the threshold of death, she could receive appropriate medical care that we felt like we weren't yet able to give due to lack of clarity in the state law.
Are you aware of other patients who have had to be medically transported out of state from St. Luke's?
Yes,
Approximately how many?
approximately 6 or 7.
Objection, lack of foundation for personal knowledge.
6 or 7 since when?
The beginning of this year, 2024.
Do you have an example about how the abortion bans have affected your treatment of a patient with a lethal fetal condition?
Yes.
Could you describe that example?
Sure. Since my time at St. Luke's, a patient was referred to me with concern of a fetal anomaly with the bowel wall. That's a very common referral question, and generally the outlook of small defects in the abdominal wall are quite good. However, when I met this patient, there was a significant abdominal wall defect, commonly known as body stalk anomaly. In this anomaly, the lower chest and the entire abdomen are open, and the abdominal organs are typically adherent to or stuck to the placenta. In this case, during this prenatal diagnosis, the liver, bowel, and bladder were stuck to the placenta, and the baby was in a persistent breech presentation, or butt first. In body stalk anomaly, that is a lethal anomaly. Those babies do not survive after birth. We had a frank discussion about options, as is common and standard medical care. I offered her termination and expectant management. But I gave her the caveat that with expectant management in this particular anomaly, the fetus typically doesn't move in the bag of water because its abdominal contents are stuck to the placenta. And so, as is often the case, those patients may require a major abdominal surgery, a cesarean section, to effectively deliver the fetus that will not survive. And so we talked about the potential of a major abdominal surgery for her with really no benefit to the fetus and a potential negative impact on her future fertility.
And what did the patient tell you that they plan to do?
The patient expressed a desire for out-of-state termination.
Was this patient able to obtain the standard of care treatment for her condition in Idaho?
No, she was not.
In your experience, why do some families who've received a lethal fetal diagnosis choose termination?
I think there are a multitude of reasons. In truth, based on the individual circumstances of which they're presented, patients often feel that in the context of consideration of their own health, of the health of their fetus, of what they view as right and just, in the context of their own societal norms, spiritual, religious preferences, and within their own support group, they're making the best decision that they feel that they can make when they're faced with two awful decisions.
Do you have an example of how the abortion bans have affected your treatment of patients with multiple gestations?
Yes.
Could you
object for relevance? Again, these patients are not plaintiffs. He's not a plaintiff. In this as applied challenge, it's not relevant, and it's cumulative to the other testimony as well.
Yes.
Can you describe that situation, please?
Since our time at St. Luke's, I've cared for a patient with a triplet gestation. Generally, higher order multiples, twins, triplets, quads, are at significantly high risk of preterm birth. In this particular instance, one of the twins had a lethal fetal anomaly called anencephaly.
I just interrupted you. You said twins. Did you mean triplets?
Triplets, yes, I apologize.
Continue.
One of the triplets was affected with a condition called anencephaly. In this condition, the skull bone doesn't form correctly. And over time, the amniotic fluid.
For expert testimony again. I mean, they're getting in a lot of expert testimony in a way that I think is improper. So I'll again object and move to strike.
Understood, overruled. You may continue your answer.
Thank you. In this particular instance, because the skull is malformed, over time the fetus won't swallow, and so fluid begins to build. The potential impact in a triplet pregnancy, where one twin who has a massive increase in their fluid dramatically increases the risk of preterm birth. And so we discussed termination of pregnancy, and in a triplet pregnancy, we discussed that in terms of what's called a selective reduction, to reduce the triplet pregnancy to a twin pregnancy, mainly to benefit the co-surviving twins who are non-anomalous. In other words, by doing a selective reduction, the patient reduces the neonatal risk to the other twins, thereby furthering the length of pregnancy, reducing the risk of prematurity, complications after, and potentially morbidity or mortality.
You mentioned selective reduction. Is that technically an abortion?
Yes.
And what did this patient tell you that they plan to do?
She planned to seek out-of-state procedure for selective reduction.
Did she do that?
She did.
And then what happened?
She returned back to our practice clinic and had a successful delivery of her twins.
Dr. Harmon, what impact does it have on your practice to have to tell your patients that they have a lethal fetal diagnosis, but that they have to remain pregnant or leave the state?
Objection, relevance.
Impact on his practice,
Yes, Your Honor.
relevance.
The impact to an MFM's practice and their ability to care for their patients, I think, is at the heart of this case.
All right, I'm going to sustain the objection.
All right, nothing further, Your Honor.
Cross-examination, Mr. Craig.
Yes, Your Honor, thank you. Good afternoon, Dr. Harmon.
Good afternoon.
Discussed the situation involving a pre-prom patient. When was that? When did you treat that patient?
Within the last 2 years.
And can you be any more specific?
Your Honor, I'm going to object to getting, the doctor is not allowed under HIPAA to say the month or year. He could say the year, but HIPAA precludes him from getting any more specific than that.
I believe there's an exception for the court to order him. I mean, if they're presenting evidence like this, we're entitled to cross-examine and get information. They opened the door to it.
In terms of identifying information, are you going to be seeking anything other than a closer approximation of the time frame?
Having the month and year would be helpful.
Well, I'll overrule the objection, permit you to provide that information if you recall.
I'll add relevance to the objection as well.
Well, I think he's entitled to explore on some level the incident the doctor has described as, because among other things, he's not entitled to accept it all as factually true, that it happened. So that enables some inquiry to attempt to verify the incident. So if you can.
Your Honor, I apologize. If we are going to do things that are going to cause him to violate HIPAA, I'm going to have to ask that we clear the courtroom.
Well, I don't mind, but it's not a HIPAA violation if he's directed to do it. But it's certainly to whatever extent it is protected information under HIPAA, then certainly it would seem that it would be appropriate to consider it as confidential information within the confines of the protective order, and to have that portion of the testimony conducted in a closed setting. Now, Mr. Craig, I guess I'll put it to you whether what I'd like to do is, if we're going to have any portions of this testimony closed, that it be that we not go in and out of closing. So I wonder whether you want to pursue this topic now, or whether you want to do whatever you think you can do else without needing to close the courtroom.
We could pursue this line of questioning now, clear the courtroom. I'll try and get all of my questions on those together, and then I'll do the ones that I don't think need to be.
Okay. Understood. So we will shut down the live feed out of this confidentiality concern. Ask those who are in the courtroom, who are not moment to invite folks back in before we resume. All right, go ahead, Mr. Craig.
Thank you. You started practicing at St. Luke's in August of 2022, correct?
Correct.
From in the little over 2 years, approximately how many patients have you treated during that time?
I wouldn't even venture to guess 1,000 or more.
Aware of any Idaho doctors that have been criminally prosecuted for performing an abortion since the Defense of Life Act went into effect?
No.
Aware of any doctors who have been subject to professional discipline since the Defense of Life Act went into effect for performing an abortion?
No.
Thank you. I don't have any other questions.
All right, thank you, Mr. Craig. Any redirect?
No, Your Honor.
Thank you for being here, Doctor. You may step down. Plaintiffs may call their next witness.
Plaintiffs call Elizabeth Woodruff.
All right, thank you, Ms. Davey.
Good afternoon. Would you please state your name for the record?
Terry Elizabeth Woodruff.
Ms. Woodruff, what do you do for a living?
I'm the executive director of the Idaho Academy of Family Physicians
And how long have you been in that position?
since April of 2020.
What is the Idaho Academy of Family Physicians?
We're the member organization for family physicians in Idaho,
And what is it commonly called?
the IAFP,
Where is IAFP based?
Boise, Idaho.
Are you familiar with IAFP's mission?
I am
What is it?
to advocate on behalf of family physicians and their patients.
And how does IAFP carry out its mission?
We implement our mission via our strategic plan, and that includes a variety of program initiatives, continuing medical education, networking, and other educational materials for our members.
Are you familiar with IAFP's membership rules?
Yes,
And how is it that you are familiar with those?
it's my job to understand those rules.
Who can become a member of IAFP?
To be a member of the IAFP, you have to practice in Idaho, you have to be board certified in family medicine, and you have to pay regular dues as well as complete certain medical education requirements.
Are you familiar with the composition of IAFP's membership?
I am.
And how is it that you're familiar with that?
It's my job to track and calculate the membership.
How many members does IAFP have?
We have approximately 800 total members and approximately 650 active members.
Are there different categories of membership?
There are.
And what are those?
We have student members, we have resident members, we have new physicians, active members, as well as lifetime retired members
And where are IAFP members located?
in every part of the state.
How many IAFP members practice in rural areas?
Approximately 25%.
And how many IFP members practice obstetrics care?
Approximately 1/3.
How many employees does IAFP have?
Just one.
And who is that?
That's me.
What are your job responsibilities at IAFP?
I do everything from top to bottom at the organization. I do the administrative functions of the work. I design continuing medical education curriculum in collaboration with my members and board. I run and facilitate board meetings and interactions with our board, and I implement our programs.
As executive director, are you familiar with IEFP's organizational structure?
I am.
And how is IEFP governed?
We're governed by a physician board of directors.
How is IEFP's board of directors chosen?
They're elected on an annual basis
And
by our members.
do you interact with the board in your role?
Yes.
And how is that?
I interact with the board on a regular basis via email. I interact with the leadership of our board, known as our executive board, on a very regular basis, weekly, daily, and monthly. I interact with the full board 3 times a year through board meetings, but also through electronic communications as well as committees of our board.
How does IEFP decide what issues to prioritize in carrying out its mission?
Every 5 years, we develop a strategic plan during our board meetings, and we identify long-term, midterm, and short-term goals.
What factors influence IEFP's priorities?
Some of our priorities are determined by larger, long-term initiatives within medicine, and some are determined via more short-term, urgent issues related to policies in Idaho.
Do IEFP members have input in those priorities?
Yes.
What are IEFP's current priority areas?
Some of our main priority areas right now are protecting the physician-patient relationship, supporting and enhancing Idaho's physician workforce, preventing teen suicides via screening and referral, and reducing physician burnout and increasing physician well-being.
Do any of those priorities encompass reproductive health care?
Yes.
And which priorities are those?
The main is interfering in the physician-patient relationship and preventing that interference, as well as workforce.
How is
I'm going to object to anything getting to workforce as irrelevant and within the bounds of what the court's already decided.
All right, understood. And that may arise as the questioning proceeds. I don't think that individual response warrants any kind of striking. So we'll allow it to stand. You may continue.
How is reproductive health care related to preserving the physician-patient relationship?
There have been changes in Idaho's laws that have impacted the ability to deliver reproductive health care specifically by interfering in the physician-patient relationship.
Your Honor, we'd object lack of personal knowledge, lack of expert testimony. No foundation has been laid as to a legal expert, medical expertise, any of those.
Overruled. Answer stands. You may continue.
All right, and how is reproductive health care related to protecting the physician workforce in Idaho to the extent that is the priority that you identified earlier?
Objection relevance.
All right.
Your Honor, I believe this goes right at your ruling.
Your Honor, I am laying the foundation, and this is not the line of questioning we discussed earlier.
How is reproductive health care? The question again, please.
How is reproductive health care related to IEFP's priority area of preserving the physician workforce?
I'll permit that question to be answered. Go ahead.
Could you restate the question?
How is reproductive health care related to IAFP's priority area of preserving the physician workforce?
Same objection.
Understood. Overruled. You can answer that question. There are likely to be limits on this topic as it goes on.
Reproductive health care has had an impact on the ability to recruit and retain physicians in Idaho, as well as family physicians.
Do you remember?
Move to strike, lack of personal knowledge.
All right. I think at this point, I am going to grant the motion to strike the last answer. If you have further questioning along those lines, it may be appropriate to make an offer of proof. Alternatively, if you got questions that don't touch on this physician flight type issue, you can ask them.
We'll make the offer of proof later on in the examination when this issue comes up. Okay. How do member concerns influence what work is prioritized?
Yes.
And how is that?
We look to our members to identify priorities within our mission. We do that through an annual member satisfaction survey, sometimes some specific individual surveys. We gather member input through our events and presentations, and we utilize members of our board that serve throughout the state to share information from their communities.
Now, are you a physician?
I am not.
What was your experience advocating for family physicians before you started your role at IAFP?
I've worked in public policy in Idaho for over 15 years, and specifically in healthcare advocacy since about 2014. I worked with physicians on other policy efforts related to healthcare.
Have you had to learn about family medicine practices in particular through your role in IAFP?
I have.
And how have you done that?
By engaging in the course of work in my job. It's my role to serve, and it's an honor to serve the family physicians of Idaho. And I've learned a lot about how they practice medicine, the patients they serve, and the impacts to health that they have.
As part of that process, have you learned about IAFP members' concerns about patients?
I have.
How do you determine, in general, as part of your role, what your IAFP member concerns are? What is the process you follow?
There are a variety of processes to do that.
Hold on just a moment. I believe counsel is making an objection.
That objection vague.
All right, understood. I'll overrule that objection. You may continue.
We work. My job is to be a sounding board for members. So our members communicate their concerns, questions, and suggestions to me in a variety of ways. Sometimes I receive emails. We issue emails and sometimes get responses. I receive phone calls. I participate in a variety of meetings. And as I stated before, we conduct regular surveys of our members and utilize our events and presentations to receive member feedback.
Who else at IAFP receives member feedback besides you?
I ensure that member feedback is delivered to my board of directors.
Do the members of the board of directors also independently receive feedback from IAFP members?
Yes, it's very important to utilize our members to provide information they're hearing from their colleagues in their communities.
Objection outside of personal knowledge, hearsay.
Overruled. Answer stands. You can continue.
What do you do with the information that you receive through these processes that you've described?
I make sure that I note it and that I provide written documentation of it to my board, and specifically my executive board, which are my board leaders. And then depending on strategic conversations with my board, we identify actions that we can take to support member concerns.
How is the information that you and the board collect from these processes used?
We look at how that information relates to our identified strategic plan and our missions, and then we determine a strategic approach, a work plan, a series of goals and tactics in order to resolve member concerns.
Are you familiar with whether IAFP members who provide obstetrics care in Idaho treat patients with pregnancy complications?
Yes.
And how is it you're familiar with that?
There are a variety of members on my board that have described that to me, and through the other avenues that I've described, I've received that information.
Objection, hearsay. There's been 4 to 5 mentions of conversations and discussions.
Well, at this point, she hasn't relayed anything she's been told. She's just indicated how she has familiarity with information on a certain topic. So it doesn't appear to me that there is a hearsay concern with the testimony given. I'll overrule the objection. Go ahead.
Do family medicine providers in Idaho treat patients with pregnancy complications?
Yes.
Are you familiar with the laws at issue in this case?
I am.
How is it you're familiar with those?
It's a central part of my job to review relevant laws that may impact my members and relay that information to my members.
What is your general understanding as a layperson of the laws that are challenged in this case?
There is a fetal heartbeat law that has civil and criminal penalties, and then there's a total abortion ban. And both laws have very limited exceptions, although the exceptions are not the same in both instances. And the total abortion ban is, I understand, to supersede the fetal heartbeat law in terms of its provisions.
When the abortion bans went into effect, did you follow your usual process for determining member concerns?
Yes.
What did you determine about member needs and concerns related to the abortion bans through that process?
Objection, hearsay.
Your Honor, this is not being offered for the truth of the matter asserted. It's showing the effect on the listener. This is also her determination that she made based on these communications. I'd also say it's not hearsay because it's not, it's explaining subsequent conduct, which I'm going to connect up.
Your Honor, it necessarily includes the matter asserted because they're trying to say because of X communication, Y action was taken.
Which is a hearsay. It's not hearsay.
Overruled. You can answer.
That there was an urgent need to address member confusion regarding delivering the standards of care and preventing patient harm as a result of Idaho's abortion laws.
What did you do in response to this information?
I took a variety of actions to provide clarity, address those concerns, and resolve them for our members.
How did member concerns factor into what IAFP decided to prioritize in the time period after the abortion bans went into effect?
There was such a urgent, great need described by our members that it became a top priority of our organization.
In your role as executive director, are you familiar with other medical specialties that impact the work of family physicians?
I am.
And how is it that you're familiar with that?
Part of my job is to understand that so that I can support my physicians in doing their work.
To your understanding, are there particular specialties that impact IAFP members who practice obstetrics?
Yes.
And what are those specialties?
Obstetrics and maternal fetal medicine specialists.
Are you familiar with how the work of maternal fetal medicine specialists interact with the work of family physicians?
Yes.
And how are you familiar with that?
Part of my job is to understand that relationship, especially in relation to these policies.
And what is your understanding of how MFMs interact with family medicine providers who provide obstetrics?
Family physicians who provide OB, especially in rural areas, rely on the input of maternal fetal medicine specialists when they're dealing with complicated situations in their very remote rural communities. It's a very collaborative relationship, and the outcomes for those patients are dependent upon the quality of that relationship.
And what is your understanding of how OBGYNs interact with family medicine providers who practice obstetrics?
My understanding is that that's as well a very collaborative and coordinated relationship, and that there's a lot of consultation between family physicians and OBs, again, because so many patients receive their OB care from family physicians. A lot of colleague communication happens across those specialties.
Does IAFP have a process for identifying concerns of OBGYNs to the extent they impact family physicians?
Yes.
And what is that process?
We are involved in a variety of coalitions that allow us the opportunity to communicate with physicians in other specialties.
Do you have a similar process for identifying concerns of maternal fetal medicine specialists that impact family physicians?
Yes.
And what is that process?
Again, we are involved in a variety of coalitions that create communication that allows us to get information from the maternal fetal medicine specialists.
After the abortion bans went into effect, did you follow IAFP's usual processes for determining if OBGYNs and MFMs had concerns that would impact family practitioners with respect to the abortion bans?
Yes.
What did you determine from that process?
That there was an urgent need to address concerns across specialties regarding confusion and the impacts to patients' health and safety when the standard of care couldn't be delivered in Idaho as a result of the laws.
What actions did you take in response to the information that you learned from following these processes you've just described?
I engaged in a variety of tactics in order to try to address those concerns, resolve the confusion, and make changes to the laws.
Could you describe the categories of these tactics that you used?
Yes, I developed a reproductive health committee within the IAFP board. I helped form at least 2 coalitions. I worked with my members to develop educational resources for physicians. I developed tactics to do public education, and then I worked with partners to establish an approach to legislative advocacy.
Let's start with the Reproductive Health Committee. Why was that committee created?
In advance of the Dobbs decision,
We're getting into the systemic harms again.
Your Honor, this is directly relevant to the actions that IAFP has taken in response to the bans. It certainly goes directly to their standing, which the state has directly challenged.
It doesn't appear to me to invade the area that I have expressed concern about at this point. I'm going to permit you to answer the question.
in advance of the Dobbs decision, I had been asked by my board to track potential changes to reproductive health laws in the state. As we began to track that, we anticipated that there would be changes, and my board directed me to form a committee of our members focused on reproductive health.
Who was asked to serve on that committee?
The initial invitation went to our board of directors, and then we also approached experts within our membership in OB care, and we put out a general request to our members.
Do you have a role within that committee?
Yes.
And what is that role?
My role is to facilitate the committee in a variety of ways, to compose it, to schedule its meetings, to identify an agenda in collaboration with the chair of my committee, to set calendar items, invite members to it, to facilitate those meetings themselves through the agenda, to take notes, and then to issue the minutes from those meetings, as well as to work with my members to implement the tactics identified within the committee's work.
Does the committee have a process for identifying its goals?
Yes.
And what is that process?
That work is done through establishing the agenda and having conversations in our meetings where our members bring in information, where I share information that I receive from colleague organizations, and where we identify what the most urgent needs are.
What were the goals of the committee initially?
Prior to the Dobbs decision being issued, we wanted to prepare information that would generally be helpful in interpreting how changes in the law would impact physicians and their patients.
Did those goals change at any point?
Yes.
How did they change?
Immediately following the Dobbs decision, when the reality of the laws sunk in, it became clear that there was very severe confusion about the laws and that there was an urgent need to try to address that confusion.
Action, lack of personal knowledge, hearsay.
Overruled.
What new goals did the committee establish after the Dobbs decision?
We developed a series of resources to assist our members and the medical community more broadly in trying to understand the laws and what it meant about the practice of medicine.
What particular actions did the Reproductive Health Committee undertake to achieve those goals?
Our first action was to establish a website that would have a variety of resources for physicians to access that we didn't create, but then also we identified resources that needed to be created, as well as opportunities for medical education on the topic.
What types, you mentioned that you've created resources. What types of resources did IAFP create in response to the abortion bans?
Action relevance.
Overruled. You can answer.
Initially, we focused on changes to clinical workflow for our family physicians as a result of the laws, and we also offered presentations, both medical education presentations and listening sessions.
What types of presentations did IAFP put on?
The first presentation that I recall was in July of 2022, and it was a presentation on emergency contraception and how Idaho's laws may or may not impact the delivery of emergency contraceptive. We also held a variety of listening sessions where we accessed legal experts in our community to hear concerns from physicians and simply describe the laws as they were written. And we had a series of presentations as the time frame evolved on topics that became pertinent, including on the interaction of EMTALA with state laws, the Planned Parenthood decision, and different pieces of legislative work.
When did IAFP put on its first listening session about the abortion bans?
Early August of 2022.
Did you attend that presentation?
Yes,
Did you play a role in it?
I did.
What was that role?
My role was to bring the experts together, design the agenda with them, ensure that the slides would be relevant to members, advertise it not only to our members but to the medical community at large, facilitate the meeting itself, and deliver follow-up resources to attendees.
Did IAFP members attend that listening session?
Yes.
How about physicians from other specialties?
Yes.
Do you recall about how many attendees you had?
I believe it was upwards of between maybe 25 or 30.
What was the purpose of this listening session?
To describe Idaho's laws and to hear what questions physicians had.
Who were the presenters?
I worked with a couple of volunteer legal experts in our community.
Why did IAFP determine that it had to explain the laws in this presentation?
We had overwhelming
And lack of personal knowledge, hearsay.
We had overwhelming feedback from our members and the physician community at large about confusion.
Same objections.
Overruled.
Does IAFP typically provide presentations to explain to members how to comply with laws that impact their practices?
This is the first time I can think that we had to do that.
What was different about this situation that prompted you to provide this listening session?
There was a very time-sensitive urgency. We provided it prior to the laws actually going into effect in the state, and it was focused on legal questions that we normally didn't have to address. The standards of care are usually eminent in our medical education presentations, and in this case, there was confusion about what those were or how the laws impacted them.
When you were putting together this presentation, did you rely on the processes that you described earlier for identifying IEFP member concerns?
Yes.
And did you rely on the processes for identifying concerns of OBGYNs and MFMs?
Yes.
Now, does IEFP have a process for soliciting feedback after presentations?
Yes.
And what is that process?
We typically offer a survey following a presentation, and we also utilize feedback during the presentation and at its conclusion, as well as invite attendees to communicate with us in whatever format works for them.
How does feedback occur during the presentations?
At the presentation's conclusion, there's a question and answer period that involves solicitation of clarity that's been provided through the presentation.
Did you follow your usual processes of soliciting feedback from attendees during this listening session in August of 2022?
Yes.
And what did you determine based on that feedback?
Attendees were incredibly appreciative of our efforts and remained confused and very concerned.
Objection, hearsay, getting at statements.
Overruled.
What did you do in response to that feedback?
Worked even harder to try to provide the resources that would be necessary for the physician community to have more clarity, but also became very urgently focused on the need for legislative action to change the laws.
Did IAFP put on additional listening sessions after the one you described in August of 2022?
Yes.
When was the next presentation?
My recollection is that we did our first EMTALA presentation in early December of 2022.
And that presentation was about the EMTALA law?
Yes.
Would you just
Relevance?
Overruled.
Would you just generally describe what that presentation was about?
I had received I became aware of an urgent need to clarify how EMTALA interacted with state laws, and so contacted the Center for Medicaid and Medicare Services director of EMTALA, as well as an attorney that had expertise in that, in order to provide another listening session focused on that issue.
And did you become aware about concerns related to EMTALA from the processes that you usually follow for identifying IEFP member concerns?
Yes.
Did you play the same role organizing this presentation as you did the one in August of 2022?
Yes, this took a lot more work.
How much could you describe the additional work it took?
We wanted to make sure that hospital systems also had the information, because I became aware that that was a need. And it also took a lot of work to communicate with the Center for Medicare and Medicaid Services, find timing that we could collaborate with other medical associations that would work for people, and then prepare an outside speaker to the state and a legal expert to work together to provide that information. So it just took a lot more coordination. In fact, I probably began that work in October and wasn't able to deliver it until December.
Did anyone help you prepare that presentation?
I discussed it with my reproductive health committee and my board. I received contacts through colleagues and worked with the presenters themselves, of course, to finalize the approach.
And again, who were the presenters?
The name of the director of EMTALA at CMS at the time has escaped me, but the legal expert in Idaho was Kim Stanger.
Did IEFP members attend that listening session?
Yes.
And did other physicians attend that listening session?
Yes.
Did hospital administrators attend that listening session?
Yes.
Did you solicit feedback during that listening session in the normal course that IEFP solicits feedback during presentations?
Yes.
And what did you determine from that feedback?
Again, there was a lot of
Overruled. You can answer.
There was a lot of appreciation for the effort of information that felt very relevant to people. There was some relief at having more information, but there was still a lot of concern and confusion about the interaction between the two laws on how care could be delivered.
What two laws are you referring to?
Well, the state's total abortion ban and then the federal EMTALA.
How did IEFP respond to the concerns you just described?
We created a whole section on our website about the EMTALA pieces. We linked to federal resources about the EMTALA requirements. We distributed it widely to our members and others through our coalition work. I believe we even worked on opinion editorials with physician experts to discuss it to the public.
Did IEFP do a listening session on any other topics related to the abortion bans?
Yes.
And what was that listening session about?
Following the Planned Parenthood v. Idaho decision, we held a listening session regarding what that decision entailed and how it might impact care.
And who participated in presenting that listening session?
My recollection is that it was Kim Stanger again.
Did IAFP members attend that session?
Yes.
Did other physicians from other specialties attend that session?
Yes.
Did maternal fetal medicine specialists attend that session?
Yes.
And did OBGYNs attend that session?
Yes.
Did IAFP solicit feedback after that session in the normal course?
Yes.
What were you able to determine about the abortion bans after that listening session?
that there was an urgent need for the IAFP to achieve a better health exception in the legislature.
Did that feedback reveal that any concerns that you had previously identified were no longer present?
Yeah, yes, I think that the Supreme Court decision did clarify a couple of conditions, but the questions about broader impacts to patient health and the delivery of care remained urgent.
You mentioned that you were involved in forming 2 coalitions in Idaho. Would you please describe what those coalitions are?
The first coalition that comes to mind is something that we call the post-Roe think tank. Within 1 week of the Dobbs decision, I helped to form a coalition of legal experts, medical association personnel, other health advocates, and physicians that would gather and still gathers on a weekly basis to discuss the impacts of the laws and work that we can do to support each other in creating clarity in the laws. The other coalition has come to be known as the Idaho Coalition for Safe Healthcare. And this was a coalition focused on bringing healthcare providers together to discuss the laws and address physician and other healthcare provider concerns.
Is the post-Roe think tank a resource that you consult in determining concerns or impacts for IAFP members?
Yes.
Overruled. Answer stands.
And is the Coalition for Safe Healthcare a resource that you rely on to identify potential concerns of IAFP members?
Yes.
You mentioned earlier that maintaining the physician workforce is one of IAFP's priority areas. Does IAFP have a process for identifying threats to the physician workforce in Idaho?
Yes.
Relevance right at the court's order.
All right, I think we are there at this point. I'll sustain the objection if you'd like to make an offer of proof, just simply by reciting yourself, counsel, what you expect your questioning on this line would elicit in the way of evidence. You may do that.
Yes, Your Honor. If permitted to testify, the witness would describe that IAFP has a process for identifying threats to the physician workforce. That process is similar to the other processes that Ms. Woodruff described in terms of identifying harms directly from IAFP members, as well as specialists like OBGYNs and MFMs who have an impact on the provision of obstetric care by family physicians. She would testify that there have been concerns raised by IAFP members as well as members of OBGYN and MFM specialties about declining numbers of OBGYNs, MFMs, and family medicine providers of obstetrics care in Idaho since the abortion bans went into effect, and that decrease in physicians practicing those specialties and in those areas of care have contributed to physician burnout and have contributed in some cases to delays in patient care. For example, not being able to consult with an MFM in Boise promptly when treating a patient with pregnancy complications.
All right, thank you. If you have other questions on other topics?
I do, Your Honor. Ms. Woodruff, you mentioned that you engaged in public education. Would you describe what that is or what that was in relation to the abortion bans?
Sure.
Relevance.
Is this just go to establishing the organization's interest in the subject, and as part of this showing of standing, or does it relate to something else?
Your Honor, during the pretrial conference, you indicated an interest in only having witnesses testify once. Defendant's medical expert has alleged that IAFP has a duty to educate the physician workforce in Idaho in how to comply with the bans, and that it is the fault of IAFP in particular that physicians do not know what the law is. So far, Ms. Woodruff has described efforts that IAFP has taken that certainly contradict that expert opinion. And this is an effort to front load that information as was discussed during the pretrial conference.
Additional evidence on the subject of IAFP attempting as best it can to inform its members on the effect of Idaho's abortion laws on permissible medical care.
Yes, Your Honor.
I'll overrule the objection. You may ask a new question. The first question, I believe, has been answered. So go ahead and continue.
What is your role in carrying out IAFP's public education actions related to the abortion bans?
No objection.
Okay, overruled.
It's my job to design that work, work in coordination with my physician members and others to develop the work and then to implement it.
What types of public education actions has IAFP taken related to the abortion bans?
The main pieces of our public education work have been done through earned media. We also, obviously, as I've already stated, have our website, and we have participated in a variety of community conversations and presentations on the topic.
About how many op-eds about the abortion bans did IAFP assist with publishing since the abortion bans went into effect?
Approximately 15 to 20.
And what were the general topics of those op-eds?
The op-eds first tried to inform the public, members, and obviously lawmakers about the confusion about the laws, the impacts to patient safety, the harms to our community, and the impacts on physician well-being and retention in the state.
Objection, hearsay getting at statements.
All right. So I think just the mention of the topic of retention without going further into it does not trigger an overall concern. I'll overrule the objection. You may continue.
Were those op-eds written by physicians?
Yes.
Were any of those op-eds written by maternal fetal medicine specialists?
Yes.
Do you recall about how many?
Probably 4 from MFMs.
Were any of those op-eds written by OBGYNs?
Yes.
Do you recall how many?
4 or 5.
Were any of them written by hospital administrators?
Yes.
How many?
Maybe 2 or 3.
Now, finally, let's talk about IAFP's legislative advocacy that you mentioned. Generally, on what issues does IAFP engage in legislative advocacy?
Any issues that would impact our physicians' ability to practice medicine.
Does IAFP have a process for determining what issues for which it will engage in legislative advocacy?
Yes.
And what is that process?
As I mentioned before, our board comes together as a whole 3 times a year. At our fall meeting, we have a robust conversation about what may be coming during the legislative session. We are a small organization, so we then determine what the most urgent issues are, and then it is my charge to develop a work plan to address those issues. I then report on that in the January board meeting.
Is IAFP a partisan organization?
No.
Are you familiar with how IAFP engages in legislative advocacy in general?
Yes.
Would you describe that process?
I'm registered as a lobbyist in the state of Idaho. We develop educational materials to provide to lawmakers. We hold an annual legislative reception every year. We have one-on-one meetings with relevant lawmakers, depending on the topic. We participate in testimony before committees, and then we also assist our members in generating emails and other written communications to lawmakers.
In carrying out that process that you described, does IAFP engage with elected representatives from both political parties?
Yes.
I'm going to direct you to what's been pre-marked as plaintiffs PX 486, which is tab PX 486 in your binder. Do you recognize this?
Yes.
What is it?
This is a fact sheet we created to distribute to legislators about Idaho's abortion laws in the 2023 session.
Who created this?
I did in consultation with my reproductive health committee members.
And how was this used?
We emailed it to lawmakers. We provided hard copies that were delivered through legislative services, and we distributed it at our annual reception. We also put it on our website.
Is this document kept in the course of IAFP's business activities?
Yes.
Where is it kept?
It's kept on the IAFP laptop as well as our website.
And are you familiar with IAFP's usual practices for storing documents?
Yes.
Who is responsible for storing documents at IAFP?
I am.
Is it IAFP's regular practice to store documents like this?
Yes.
Was this document stored on IAFP's laptop at or near the time it was created?
Yes.
Plaintiffs offer Exhibit 486 into evidence.
Any objection?
Objection on the basis of hearsay.
All right, response?
Your Honor, Ms. Woodruff created this document, and she has stated that it was used to carry out IAFP's legislative advocacy, which is part of their standing in this case. It's also part of the efforts that they use to educate the public.
I don't believe that.
And that's been put directly, that's been challenged directly by defendants. This also is evidence of actions that IAFP took in response to member concerns.
Well, it seems to me that the document is, I think it's been authenticated, and its existence is relevant, if for no other purpose than to demonstrating IAFP's standing, which is in question. But I think that the document itself, I think, is difficult to say doesn't amount to hearsay. Certainly, the organization's regular practice isn't. Its regular business practices don't involve the preparation of information materials on the subject of how these laws work, et cetera. So I think what I'll do is admit the document, but not for the truth of the matter asserted, and just as it goes to the demonstration of an organizational interest in the topic at issue.
Set that aside. Ms. Woodruff, do your responsibilities for staying current on the concerns of IAFP members continue during legislative sessions?
Yes.
Did you continue that process during the 2023 legislative session?
Yes.
What did you determine from that process about IAFP members' concerns related to the abortion bans after that session concluded?
that there was an urgent need for the IAFP to continue to address member concerns that were unresolved by the Idaho legislature regarding Idaho's abortion laws.
My final question is, why did IAFP decide to bring this lawsuit against the state of Idaho?
Sorry. We had done everything we could think of to try to resolve the concerns of our members and were otherwise unable to do so.
Thank you. I'll pass the witness.
All right. Thank you, Ms. Dady. Mr. Grigsby, cross-examination?
Your Honor, at this point in the day, we don't have an exact time frame on the length of our cross, but concerned we may go over time.
Let's go after it. I guess I'm gonna guess I'd be surprised if you're still going in a half an hour, but we'll see.
Good afternoon, Ms. Modrow.
Good afternoon.
You are Executive Director of IAFP.
I am.
You have prior positions that served similar functions to your functions at IAFP.
I have.
Can you describe those?
I have been serving as an executive organizational leader since 2011. I was the director of an environmental organization in the state for 3 years, and then in 2014, I moved to a children's health advocacy organization and was promoted to assistant director in 2015 and served in that role until 2020.
Was there an advocacy aspect in at least some of those prior positions?
Yes.
And can you very briefly describe what that entailed?
Objection, relevance.
My role was to advocate based on the missions of both the organizations that I represented in terms of their interests. So that would be developing content when I worked for member organizations to get members involved in advocacy on certain issues, and then working broadly to implement advocacy on the variety of topics we worked on.
And what were a couple of those main topics?
The main focus of my work over the last decade was on Medicaid expansion.
Tell me about your undergraduate education.
Objection, relevance. She's not testifying as an expert.
Isn't. I mean, I suppose some limited examination into a person's background generally happens on direct. I'm not sure. I'm not sure where this is headed. What does it matter? What degree our witness has or doesn't have?
Let's get into her knowledge and prior experience, which relates to the opinions she's provided. I think it's a pretty simple foundational question.
Provided any opinions?
That relates to generally the opinions she's asserted based on what background she may have.
Didn't understand her testimony to be opinion testimony at all.
Or her testimony generally.
All right, well, it sounds like we're headed down a wrong path. I'm going to sustain the objection.
You completed medical training?
I have not.
Are you a licensed medical provider?
No, I am not.
Completed any legal training?
No, I have not.
Are you a licensed attorney?
I am not.
IFP engages in advocacy for the organization and its members, correct?
That's correct. We advocate on behalf of family physicians and their patients.
IFP has an employee who is a lobbyist, is that right?
No,
IFP has never had an employee who is a lobbyist?
that's correct. No employee.
I believe there's a binder up there.
Okay.
And it's a white binder, 1 of 3. And could you turn to tab 17?
Oh, sorry. It would be over here.
It should say 1 out of 3, and then the tab is 17, and the page on that tab is 43. 43.
I'm sorry, I'm a little confused if I'm looking at the right binder.
Okay, so if you open the binder, it'll say 1 out of 3, and then
Yes.
there will be a tab 17 within that binder. And then does it
Oh, yeah.
deposition?
Yes, now I know I'm in the right place. Thank you.
And as you move through those pages, there will be 4 on a page, and you'll go to page 43.
Page 4 of 3?
43.
43. Okay. I'm at 42 through 45. Oh, I see. I get it.
Could you read from line 16 to 24?
The IAFP will pay other people for certain work, such as for legislative session, we've paid a lobbyist.
It's line 15 that includes the question.
Oh, sorry. Could you tell me the line numbers one more time?
Yes, 15 to 24.
Does it have any other paid employees? The IAFP will pay other people for certain work, such as for this legislative session, we've paid a lobbyist. And I know that Liz has had an assistant on and off when she feels like she has too much work, and we will pay those individuals for their time. So paid employees, Liz Woodruff as the executive director, sometimes an assistant for her, and then a lobbyist during the legislative session.
Thank you. IFP has engaged in advocacy related to medical education,
Yes,
and IFP has engaged in advocacy related to birth control.
we have done some limited advocacy on that. It was an area that our reproductive health committee identified early on. We haven't had time to do as much on that as we would like. But during the last legislative session, we did work on a contraception bill, yes.
IFP has engaged in advocacy related to sex education.
Again, it's an area that we would like to do work in. I cannot say that we've robustly done the advocacy given capacity concerns.
But at least some form of advocacy in the realm of sex education, correct?
Very limited, yes.
And IFP has engaged in advocacy related to reproductive health care.
Yes.
And IFP has engaged in a significant amount of advocacy related to abortion as well, correct?
We have worked to protect the physician-patient relationship as it relates to Idaho's abortion laws.
Generally on the topic of abortion, right?
Yes.
Idaho's Defense of Life Act and Fetal Heartbeat Preborn Child Protection Act have not directly harmed IFP, correct?
That's incorrect.
Could you turn to what's marked as PX486? I believe we just looked at that. On the second page, could you read the portions starting with important considerations? The number 3 there under that section.
Government overreach into medicine harms patients. Physicians and patients should have the right to make their own medical decisions without government interference.
Related to this statement, IFP believes the government should not restrict a patient from having access to an abortion, correct?
The IAFP believes that physicians should be able to deliver the standard of care.
That was my question. Yes or no? IFP believes the government should not restrict a patient from having access to abortion, correct?
I'm going to require her to answer the question a different way than she did. The answer was responsive.
Could you provide this to the witness?
Thank you.
Do you recognize this document?
I do.
And what is it?
This is the statement that we issued immediately following the Dobbs decision.
Your Honor, objection that this is not on defendant's exhibit list and it hasn't been identified as an exhibit by defendants.
And to try to introduce it, to question her about some statement in this document for impeachment or some sort of purpose? Where are we heading?
Related to any rebuttal or impeachment related to her statement.
All right, so you're getting at some sort of idea that something on this document impeaches something she's said so far. You can proceed, and counsel can object if appropriate, but it wouldn't be, I guess, required to number and disclose impeachment exhibits. I don't know whether it's impeaching or not. So,
All right, we'll preserve our objection to the extent that this does not appear to be impeaching anything.
it may not, but you're welcome to object on those grounds when it becomes clearer how it might be impeaching. Go ahead.
Ms. Woodruff, if you could, you see the paragraph that starts healthcare decisions about the middle of the page?
I do.
Could you read that paragraph?
Healthcare decisions should be made by patients in consultation with a trusted physician who is able to offer all information necessary to ensure informed consent. The IAFP strongly opposes any external interference in this process as it conflicts with the fundamental medical principle of patient autonomy and infringes upon the patient-physician relationship.
Okay, and then down below there is bullet points. The IFP Reproductive Health Committee is currently involved in. Could you read that last bullet point?
Supporting access to the full range of reproductive health services for all patients of reproductive age, including abortion.
Does IFP, in fact, support that last statement, the bullet point?
Yes.
And does IFP agree to the paragraph that you read above as well?
Yes.
No further questions.
Okay. Thank you, Mr. Grigsby. Any redirect, Ms. Day?
Yes, Your Honor, just a couple.
Go ahead.
Ms. Woodruff, when did IAFP make reproductive health care one of its priority areas?
I began to track the issue in the fall of 2021. It became a priority in the late spring of 2022.
Was it a priority area before then?
No.
Why not?
There weren't issues regarding our members' ability to deliver care until we anticipated changes to the laws.
Is it part of your job responsibilities as executive director to be aware of issue areas that IAFP has done legislative advocacy on in the past?
Yes.
Did IAFP engage in legislative advocacy on abortion in the past before 2021?
Not to my knowledge.
No further questions.
All right. Thank you, Ms. Dady. Anything else for this witness, Mr. Grigsby?
No, Your Honor.
Thank you for being here, Ms. Woodruff. You may step down.
Thank you.
All right. I imagine we have gone as far as we can go evidence-wise for the day. You don't have a 12-minute witness or something like that, I imagine?
We do not, Your Honor.
All right. This will be our breaking point for the week, as trial will not be in session on Friday because I have a criminal calendar that I will handle tomorrow. Trial also will not be in session on Monday. There was a counsel with a personal engagement that I accommodated, and so we will resume at 9 o'clock on Tuesday morning. I thought I might inquire before I let you go, if you can tell me on the plaintiff's side what's left of your case to present and how much time you expect what's left will take.
Your Honor, we believe we will be able to wrap up by the end of the day on the 19th. We may have one witness creep very briefly into the 20th, but we should be able to finish our case in chief by end of day on Tuesday, on the 19th.
All right, understood. And so I'm not sure what it might take in terms of assuming the plaintiffs finish on the 19th. How much time the defense case might take. Do you have an estimate of that at this point, Mr. Craig?
If they finish on the 19th, best guess without being held to is we should be done in one day on the 20th.
Understood. And this is not an attempt to set up a guardrail that you may not exceed, just for planning purposes. If, by chance, we do not finish up on the 20th, by the end of the day on the 20th, I had told you at one point at the pretrial conference that the 21st would not be available. The clerk later informed you by email that that was no longer the case. And I believe the plaintiff's side informed the court that that message was received, and if necessary, if we're still ongoing and the 21st plaintiff's side would be ready. I wanted to confirm that the same is true as to the state. Is that right, Mr. Craig?
Yes, Your Honor, we can be available on the 21st.
All right. Is there anything else anybody wants to talk about before we get back together on the 19th?
I'll just confirm that our witnesses we will have here on the 20th. So in the off chance that they finish early on the 19th, I don't want to be held responsible to have witnesses here on the 19th because from what it sounds like they may bleed over. So we'll plan on the 20th.
All right. Well, I don't necessarily have a problem with that. If your witnesses, I don't know how many witnesses you intend to call, but at least I'm aware that one of them is non-local, and so she would be traveling here as a result. If there is going to be any, I guess, estimated change in the amount of time plaintiffs need to finish up, such that you don't think you need substantially all of the 19th, I suppose you can let me and Mr. Craig know, and we can sort out whether it would or wouldn't be feasible for him to have folks here to fill the balance of the day. It doesn't sound like that's terribly likely in any event. All right, we will be in recess. We'll see you on the morning of the 19th, 9 o'clock.
All rise.